If I may, my lord, I beg to mention item 49 of the daily list today. My lord, I have taken consent of the other side. We are for the petitioner appellants.
49.
Yes, my lord.
So you are for the appellant.
Yes, ma'am.
You are for the
I am
appellant.
appealing for the respondent. Now, if convenience of this honorable court, the matter may be listed on 16th of this month, 16/5.
Let me check. 5 or 8. Can it be? Three zero. Be listed on 3035 because 14, 16, all of these are actually affected. So it will be listed on 35.
Okay.
Highly obliged.
May I please, madam? I beg to mention item number 50, madam. 50. Can it be taken up on 17th, madam? Friday.
The LCR has come and there was a stay granted by this court on the execution proceeding. The LCR has come and this is it's for hearing. So probably some difficulties on the part of senior counsel. So he requested for 17th of
17th
May.
of this month.
May.
17th, otherwise it's not a hearing day, I think.
No, it's not a hearing day, Friday.
But I can. Other case.
Then 21st, Malak,
21st. 21st.
for hearing.
17 other methods are also there.
Malak. For hearing, Malak.
Okay.
Obliged. 21st.
21st.
And my lord, there is an interim, my lord, it may be continued.
Till then.
Okay.
Till then.
It will be
Obliged.
Much obliged.
May I please your lordship? Lordship, that parity, 75 days lordship. Only considering without.
Today is actually wrongly listed for motion earlier. On earlier question, your lordship has called for the case diary, madam. I have received the case diary, madam, on 29/4 earlier listed on 29.
Lordship, actually, that day I argued lordship. Considering the parity lordship, the original accused has already been granted bail, and on the basis of the statement of the accused lordship, even search cannot be framed lordship. He was arrested only on the basis of the accused, page number 11 lordship. Kindly go to page number 11 lordship. Page number 11. During that is last part lordship, during statement of the custodial arrested accused near 100,000. Lordship, may I? Page number 11, lordship. Last part lordship. During statement of custodial arrested accused near 100,000, register officer near powerhouse confessed that he signed the fake deed and which was prepared by my petitioner lordship. So lordship, original accused is bail on has got the bail on lordship on the day of 22nd day lordship. Bail order is in 13 lordship. I am on 75 days. My mother is ill lordship. That day I informed the court lordship. Considering the period of detention and maybe charge has not yet been filed lordship, I will join the investigation and again all are documentary in evidence lordship. And there is nothing to interfere, nothing to. That I can influence the witnesses lordship. All are documented.
So Niranjan Thausan was a
He's a sub-registrar.
I was a junior clerk lordship. I was subordinate to him lordship. He signed the document. He told that I have given to him. Only on the submission of his lordship, and there is nothing lordship, and I will face the trial also lordship on the 75th day lordship today.
Yes, my lord, case diary received. Otherwise, from the he is stone arrested in this case. Otherwise, my lord, parity also cannot be a ground, and my lord, length of detention also cannot be a ground in this type of cases. Your lordship has earlier, my lord, produced many of the case diaries. Now, my lord, Leo 100,000, who was the sub-registrar of the office, my lord, on being provided by he has specifically stated that the fake deed was prepared by the present accused person. And thereafter, my lord, being a junior assistant, he, my lord, forwarded the, my lord, before the, my lord, sub register, and thereafter, my lord, he executed the document, specific allegation of the sub register, my lord, senior sub register, my lord. So he is directly involved in this case, my lord.
Lordship, then also Lordship, considering that length of detention, Lordship, I'm praying not parity, Lordship, at least length of detention, Lordship. Only 15 days left. My mother is ill, Lordship. And again, Lordship, in one of the cases, Lordship, similar matter, Lordship. I've given the copy also, Lordship. Kindly go to that para number 5, Lordship, of my petition, Lordship. Para number 5 of the petition. Maybe, Lordship. Para number 5, Lordship. The accused by Bangladesh, he was arrested initially on 24/11/2023. Initially arrested. On all the cases, I got bail, Lordship, in 10 cases, Lordship. And bail, on a very recently, he was again soon arrested by Bhangar police station. At Bhangar PS case number 40 of 2024 on 12/4/2000. And the same date, he was remanded to police custody. And here, I was being examined, Lordship. The grounds of giving bail to the near 1,000 was that he was thoroughly examined, Lordship. Lordship can go to the order, Lordship. So I am being remanded, and even the judicial magistrate also considered the same thing, that the same date he was remanded to police custody in 18/4. On 18/4, after custodial detention of the police custody, after police interrogated myself and I appeared before the judicial magistrate, I was immediately granted bail on 18/4, last date, Lordship, around 10 days ago, Lordship, 15 days ago, Lordship. Here, Lordship, I am 75 days behind the bar, and I am being thoroughly examined, Lordship. Lordship has, while perusing the while passing the order, page number 17, Lordship. I'll go to page number 17, Lordship. After hearing the submissions made by the learned counsel about the I have perused the case, this in the present was under police remand. May I, Lordship? Under police remand for a considerable period of almost 6 days, and therefore he was in custody. And from the material indication that there was no subsequent detention present inside the jail premises after he was brought before the learned judicial magistrate on completion of his police remand. In connection with the present, he is in custody for last 22 days, and thus I have got ample opportunity to interrogate the accused petitioner, keeping him in custody. The case is there is sufficient progress in the investigation, and most of the relevant documents are also seized in connection with this case. Further, it is also filed on the same fact and this case wherein the allegation of fake register deal in mutation was brought by the informant. Lordship, here the fact is that all are documented in nature, Lordship. And again, Lordship, here specifically I am praying, Lordship, at least leaving aside, Lordship, I may be police has the power to keep me till mandatory, but that is true, Lordship. But Lordship may not consider parity. And also, Lordship, police has, Lordship, while considering this prayer, police has thoroughly investigated. 75 days I am behind the bar in this case, Lordship. Finally consider my prayer, Lordship. Okay.
Otherwise, my objection is there because in this type of cases, your Lordship, length of detention, parity also, and regarding documentary evidence, why he is involved in all 11 cases, my Lord, without having any material. Everywhere, my Lord, the aggrieved person is, my Lord, different persons, my Lord. Not only case of land grabbing, my Lord, manipulation of government record. He is the junior assistant of that artist, my Lord. Otherwise, I will leave it to Lordship, my Lord.
I'll pass it. It will be a lengthy order. I'll pass the order. It will be a bit lengthy. I'll pass the order. The dictation may be a bit lengthy, so let me see the case diary and pass.
Lordship, kindly consider bail, Lordship.
Okay, see. CT to all. Whatever CT is available.
No, my Lord, item number 14, my Lord, scan.
No, it's here.
Oh, 14, my Lord.
CT. Item number 14.
My Lord, here I have check mark on the statement of the, my Lord, senior sub register, my Lord. Only in his statement.
Yes. Item number 14. Mr. M. Rahman.
No, scan copy received in this case, my Lord.
Is it charge sheeted one?
Charge sheeted case.
My Lord, may I please, Lordship? On 14/3/2014, charge has been framed, my Lord.
14th week.
14.3 probably will be on the records, my lord. 14.3. It's from Kamrup Macro, my lord. Against me, my name is Abdul Haq, my lord.
Well, earlier rejection order of your lordship
Yes, my lord.
is
I'm
at
coming
page
to
36, my lord, on 7
starting
20.
starting from page 36. The very purpose of the case listed here is only because the fact that it has already been rejected by my lordship, my lord. My lord, coming to the subject, my lord, 14.3.2014, the charges were framed, and against me, my lord, section 29. And now, the rejection orders, my lord, beside this submission, my lord, additional point will be, my lord, can straightaway come to page 14.
Scan copy shown.
So now,
My lord, today, my lord, I will have to go through the scan copy of the case report. Any date, my lord, on next.
I have
next
no
week,
objection. Definitely.
next week.
Yes, Tapada.
You can the some
Any date, any.
request for
खाली पूर्वी बंद होगा की बात नहीं अभी कई तरीके
case report.
On my lord, 9th of May, my lord. 9th of May.
oblige me
Right.
To that idea actually
Hmm?
February to start. May it please your lordship. My lord, sir, second bail application, my lord. The lordship has earlier rejected this bail application, my lord. That order your lordship will find at page 15, my lord. 1-5.
Yes.
February to start.
Yes.
My lord,
Yes.
my lord, my instruction from the client is that, my lord, we were present at that point of time, my lord. My lord, that 326 part or 307, my lord, we have nothing to do with that, my lord. We are present, my lord. Your lordship had called for the up-to-date case diary, my lord. If something is, I'll leave it to your lordship.
Yeah, I have
Well, up to date case I received, my lord. It is up to, my lord, 24/4/24, my lord. 28/4/20.
My instruction is that we are present at that point of time, but we have not inflicted anything, my lord, upon the victim, my lord. And any statement to the defect from other persons, my lord, that much. One,
This is main injury.
Bikram Burman and Vikas Das.
that fellow taken to the railway track.
Yes,
Yes, my lord.
earlier on the basis of the injured statement of the injured, my lord. Although in the FIR the name of the present petitioner
Is not there.
is not there, but from the statement of the injured person, my lord, your lordship has earlier rejected, my lord.
Yes, my lord. My lord, the role we have played, my lord, that much. My lord. If there is something
This is
in
the
the diary,
vital portion, my lord, from the earlier page, my lord. Statement of injury. Biswajit Burman,
Biswajit Burman to কোন হয়?
the injured
Victim.
victim, my lord.
মারা বুলি কৈছিল।
Your petitioner's name is
Bikram Burman and Vikas Das.
body camera, 2 photographs of the injured victim is also. Hello. Injury report is my lord previous and photograph of the my lord two
But that what sub they're not equal not if the fact that if they but they're not equal complete any of that is fair. No, they that's what they does their if them different I incorporate I but they're not but but are bit but 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 that and they will cooperate activity at that time. Therefore, it not just about the other bit that consider uh, bit, bit different. It is what the it that can not be fixed to run really with it for for it the that 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 another the conflict Your petition stands dismissed.
I am obliged.
My learned friend is the caveator in this case.
I'm for the credit.
Caveator, my lord. It has to be discharged. Society issue of some sort. My lord, first of all, we are aggrieved by an order passed by the appellate court. There was an injunction. My learned friend's client filed a suit before the learned trial, before the civil judge, and there was an application under Order 39, Rule 1 and 2, whereby there was the injunction. It's a dispute is in respect of an association. We were duly elected. That was put to challenge by way of a suit. My learned friend's client claimed himself to be the president in charge, and in his capacity, without being nominated by the state body, that is state executive body, without any nomination, I'll show it. His self-styled, he filed this suit, and we were caveator before the learned trial court. But there is no recording of our pleading, our state submission before the learned trial court. The fact, the maintainability point was also raised before the learned trial court. Now, there was an injunction which was granted. Duly elected body was restrained by the learned trial court. Against that, we preferred an appeal before the learned appellate court. The learned appellate court heard this matter. All these pleadings, all this submission was recorded. My submission totally, I will show it, all was recorded. My learned friends also submission was recorded. Ultimately, with great respect, he did not exercise, the learned trial court with great respect not exercise his mind. Only to the extent he said, there is an injunction which has been granted by the learned trial court. So we don't want to interfere at this stage, because three golden principle has been followed by the learned trial court. So no express of the mind by the learned appellate court. And that is why the learned appellate court did not interfere it, sends back to the learned trial court, objection will be filed and thereafter matter will be heard. This is a position. And the date which was fixed on 6/5/2024 has been preponed on 3/5/2024. That today is a date. My lord, I could have gone before the trial court. I know the procedure also. But why I have come up before this court? Virtually, the learned trial court, prima facie some observation is not that he has made up his mind. That yes, this is what has happened. So your particular association, we don't recognize it. That's what I will show it. But before going through all this, I will try to show before your lordship and convince that what is the locus and mentability of the plaintiff to file this suit. My lord knows that mentability point can be raised also by way of some application. If it is barred by law, it is not maintainable, there is a provision. I'll show one judgment of the Supreme Court. It says maintainability, but prima facie, the court has to come to a finding on the point if a point is being raised in respect of maintainability. That has to be decided. Now, I like to draw your lordship first attention to an act, the Society Registration Act, which is, these associations have been registered. Kindly see. It's not there?
Thank
Is there? Yeah. Okay. Please see the first, my lord, before going to the act, see the plaint, my lord. Plaint is at page 63. See the plaint, my lord, at page 63. At page 63 is the plaint.
See the cause title, Assam PWD Engineers Service Association having a register office so and is represented by its president Sri Pranab Kumar Rava. So he files this particular suit and he claims that he is an president in charge of this particular engineer service association, and he makes all the members of the association as a party. Up to it is up 31 members has been made a party. Now, if your lordship kindly see at page 70, paragraph 5, how he comes into it. Kindly see para 5. That Sri Dilip Kumar Pathak, who was the president of the Plaintiff Association for the session 2015-17, had superannuated on 28 to 2017. And thereafter, Sri Kushal Kumar Saikia, who was the senior most vice president of the Plaintiff Association for the session 2015-17, took over the charge of the president of the Plaintiff Association and also superannuated on 31/12/2019. Thereafter, the post of the president of the Plaintiff Association was taken over by Sri Pranab Kumar Rava with effect from 1/1/2020. And at present, said Sri Pranab Kumar Rava is holding the post of the president of the aforesaid committee of the Plaintiff Association, be stated herein, or that all the post of the aforesaid president is president in charge. Now, I'll draw your lordship attention to the constitution. Kindly see the constitution starting from page 86. So far as his locus, whether the constitution permits him or not, kindly see page 86 is the constitution of the association. Page 96. See kindly 11.1. President. The president of the association shall be the head of the association, and in case of absence of the president, one of the vice president will exercise all the powers of the president. In case of retirement or resignation of the president from Assam Engineering Public Work Department Service or from the association as well, one of the vice president, now my lord will kindly note down, one of the vice president shall be nominated as president in charge of the association as per the decision of the state executive committee, and president in charge shall be the head of the association. So here there is two things. One, he has to nominate it. He has to be nominated for getting this post of president in charge, but that decision has to be taken by the state executive committee. Now, if your lordship now goes back again to para 5 of page 70, paragraph 5 which I have read, not a single whisper, no statement has been made that once the president was superannuated, he was the vice president at that relevant time. So, to get president in charge, number one, it has to be nominated and the decision has to be taken by the state executive committee. Not a single averment has been made before this before the suit that he was nominated or decision was taken by the state executive committee. So that is the reason why we are questioning again and again before both the courts that he doesn't have any locus, and there is no question of this suit to be maintained. This suit automatically it goes. Now I told again, my lord, I am again repeating that maintainability point can be also taken later on, but for the purpose of injunction, whether the learned trial court would have decided that issue of maintainability. That's the main issue, first point. Now, I'll draw your lordship attention to the provision of the Society Registration Act 1860. when this constitution was made, they kept in mind the Society Registration Act 1960. My lord have seen that the provision how the president superannuated or resignation takes place, then it taken over by the vice president. Vice president is being nominated by decision of the state executive. So they kept in mind while framing this constitution under section 6 of the Society Registration Act 1860. See kindly 6. Suit by and against society. Section 6 of the Act. Lordship got it. Kindly see 6. Every society registered under this Act may sue or be sued in the name of the President, Chairman or Principal Secretary or Trustee, as shall be determined by the rules and regulation of the society, and in default of such determination in the name of such person as shall be appointed by the governing body of the occasion. Now kindly, my lord, we connect with the president, the constitution, what it says. So here also they kept in mind section 6, that it shall be determined by the rules and regulation and in default in the name of person as shall be appointed by the governing body. So here there is no appointment, no decision has been taken. He came self-styled, projected himself as a president in charge and filed this suit. So the first proposition of law is that whether he can do it. This is the first proposition of law, my lord. So, my lord will kindly, there are other points. Now, it will be easier if I connect this section 6 with page 96, 11.1, and I will show one judgment of the Supreme Court, that's a latest judgment of the Supreme Court, how the Supreme Court has dealt. Normally, a suit is being filed, we question the maintainability point. So there are provision. There are provision under Order 14, there are provision Order 7, Rule 11, it is barred by law, it's not maintainable, all this. Even then the apex court said that will be kept open, but for the purpose of injunction, whether that point can be decided by the court or not. I'll show the judgment. Kindly see 2024 SCC online SC 42. These are very latest judgments. I'll directly show para 41. Kindly see para 41. Although not directly arising in the present case, we also wish to observe question of jurisdiction would assume importance even, now kindly note down, at this stage a court considers the question of grant of interim relief, where interim relief is claimed in a suit before a civil court and a party to be affected by grant of such relief or any other party to the suit raises a point of maintainability thereof, or that it is barred by law, and also contends on that basis that interim relief should not be granted. Grant of relief in whatever form, if at all, ought to be preceded by formation and recording of at least a prima facie satisfaction that the suit is maintainable or that it is not barred by law. Such a satisfaction resting on appreciation of the averment in the plaint, the application for interim relief and the written objection thereto, as well as the relevant law that is cited in support of the objection, would be a part of the court's reasoning of a prima facie case having been set up for interim relief, that a balance of convenience is in favor of the grant and non-grant would cause irreparable harm and injury. Prejudice. Now this is, your lordship will kindly note down this. It would be inappropriate for a court to abstain for recording its prima facie satisfaction on the question of maintainability, yet proceeded to grant protection pro term on the assumption that the question of maintainability has to be decided as a preliminary issue under Rule 2 of Order 14 CPC. That could amount to an improper exercise of power. If the court is of the opinion at the stage of hearing the application for interim relief that a suit is barred by law or otherwise not maintainable, it cannot dismiss it without framing a preliminary issue after the written statement is filed, but can most certainly assign such opinion for refusing interim relief. However, if an extraordinary situation arises where it could take time to decide the point of maintainability of the suit and non-grant of protection pro term pending such decision could lead to irreversible consequences, the court may proceed to make an appropriate order in the manner indicated above, justifying the course of action it adopts. In other words, such an order may be passed if at all required to avoid irreparable harm or injury or undue hardship to the party claiming the relief and to ensure that proceedings are not rendered infructuous by reasons of non-interference by the court. I think it is very clear because maintainability point normally when it comes to the court says there are appropriate application you can file if the suit is not maintainable. But here is a judgment of the apex court where it says that at the time of whether granting or refusing of an injunction where the maintainability point has been raised, then one has to decide the maintainability. This way you refuse it or you grant it. That point was never touched either that's the pleading before the trial court, neither before the appellate court, and I will show the order of the appellate court, how it was not touched, even it was argued. So this is the first point. This is the first point I am raising about the proposition of law that the suit is not maintainable. That point was raised, even that was not considered by the learned trial court while deciding or by the appellate court while deciding the injunction application. Now my lord will now kindly see, it will be easier to connect why how the appellate court didn't decide it, that issue. Kindly see at 162, that's the appellate court's order. Kindly see 162. That's the order passed by the appellate court. 162. Yeah. 162. Now see 161. Last four line. 1, 2, 3, 4, 5 line. Bottom last 4 line, 5 lines. At page 161, that's the submission. Bottom 1, 2, 3, 4, clause 11 of the Constitution provides in the event of retirement, resignation of the president, one of the vice president shall be nominated by the state executive committee as a president in charge. In the petition, it is further stated, erstwhile President Sri Dilip Kumar Pathak has superannuated from his office on 28 to 2017. However, to the best of the knowledge of the appellant, now your lordship will note down, no nomination of any of the vice president to act as president in charge was ever made by the state executive committee. Notwithstanding the same, Sri Pranab Kumar Rama, one among the 3 elected vice presidents, started posting as a self-styled president of the association and began meddling with the affairs of the restaurant of one association. So specific argument was advanced before the learned appellate court. But to that effect, there is no finding. Now, kindly see 176. 176. Kindly see 176, the finding. See the finding at 176. Now all the facts has been narrated, his submission has been narrated. Ultimately see his finding, my lord. The learned appellate court file 176. I have so one judgment, my lord, your lordship knows Wander and Antox Limited. Their judgment in the trial court normally it is a very old judgment, 1980. I think lordship is aware of the judgment. Normally the appellate court should not interfere with the order passed by the learned trial court. Learned trial court. It could not substitute because it will amount to substitute unless you can show the arbitrariness or perverseness is there. I'll show another judgment what it says. If it is a misconstruction of a document, then of course the appellate can interfere it. Kindly see 175. 176. I have considered the submission of the learned counsel for both sides. I have also perused the impugn order dated 10/4/2024. Perusal of the impugn order dated 10/4/2024, it is found learned trial court has discussed all the three golden principles required for granting interim injunction in details in relation to the facts and circumstances of the instant case, and on such discussion, it appeared to the learned trial court that an interim injunction was required to be passed in favor of the petitioner respondent herein at this stage. Accordingly, the impugn order has been passed. However, in the impugn order, it has been clearly mentioned by the learned trial court that an interim injunction shall be enforced till the appearance of the opposite party respondent herein, and the next date has been fixed on 6/5/2024 for SRN objection. Since the interim order has been passed for a limited period so that a just decision can be taken on hearing both these parties after the written objection is filed, I am not inclined to enter into the merit of the case and to interfere with the impugn order at this stage, which has been passed by the speaking order. Learned trial court has fixed the next date, giving a short date on which the appellant will have a reasonable opportunity to ventilate the grievance against the prayer of the respondent, and as such the impugn order is not interfered with at this stage. However, having regard to the urgency shown by the appellant side, learned trial court is directed to take up the matter of hearing in respect of Midje case number so and so. Both the parties shall appear before learned trial court on 3/5/2020. So there is no finding of the learned appellate court. Only basing on the learned trial court, three golden principles has been followed. At this stage, whatever arguments you have made, I will not make any comment on the merit. That's what the order has been passed. No application of mine by the appellate court. Otherwise, we would not have come up before this court. There has to be some application of the mind with great respect by the appellate court. There is no application of mind. Your lordship has seen, and I don't want to waste time by reading the entire order of the learned appellate court. My facts, entire facts has been narrated. My learned friend's facts has been narrated, and this is the operative portion of the order. 2-3 judgments has been quoted of the Supreme Court, and the ultimate paragraph is this. So we are aggrieved and we are before this honorable court. Now, first point was raised before this. I have taken the first point regarding if it is not maintainable, because if your lordship kindly see the plaint, not a single averment has been made that number one, that I have been nominated and decision has been taken by the state executive government. Otherwise, in the plaint there should have been averment. There is no averment. Now, how it happened? Now, I will tell your lordship a bit background of this case, because I could have started with the facts, but it is easier because to connect that who is this plaintiff and file this plaint. That is why I am raising the point of maintainability. Prima facie, on the basis of the judgment, if your lordship finds a case we have made out, then of course the next point may not be looked into it, maintaining that the elected body will continue, goes back before trial court to decide this matter. That would be appropriate. I don't know, subject to how your lordship looks into it. We before the appellate court, that was our argument. They keep it maintained because we were elected. On the face of it, I will show you how we were elected. Now, I will tell you, lordship, why it was urgent for the association to put a notice to all the members of the association. This association was formed in 2015. 2015. There was virtually no activities of this association. I found one letter, the activities of the association with great respect was targeting one people. That was the activity, not beyond that. And this is not what I am saying. It is on record, I'll show it. This association doesn't look into the welfare of this association. 2015. Now, Constitution says every year there is an AGM which has to be held, and there has to be election has to take place. 2015, 16, 17, 18, 19, no AGM. Now 2020, they have said pandemic. 2020, I remember it is March when the pandemic was there, COVID. Now that was totally, it was shut down. Now in 2021, date is 12/6/2021, one letter is there. I'll show it. I'll just place it. 12/6/2021, this plaintiff, the plaintiff has written a letter saying that we could not hold the AGM on 12/6/2000 letter addressing to the association saying that we will hold the AGM by the end of 2022. Till then, let us continue it. Your Lordship will find that letter at page 103. Kindly see 103 of the revision petition, which is a part of the plaint, which is a part of the plaint. Kindly see 103. Report number 103. 103, kindly see.
Yes.
Kindly see the meeting of the executive committee of so and so held at Ganeshguri on 12/6/2021 at 6:30. See the first paragraph. The meeting adopted the following resolution. The AGM is to be held in a suitable time in 2022, and till holding of the AGM, the present executive company will continue. So their intention was that we will hold it 2022, and till holding of the AGM, the present executive committee body will continue. See the last paragraph, what I said. 3. General Secretary of the association is authorized to take initiative and to sign all necessary court-related documents to file application for impleading in the WPC in the Honorable Guwahati High Court. He is also authorized to continue with the matter as and when necessary. This is only I am pointing out. This may not be so relevant so far as the case is concerned. But I am saying, see the intention of the associate. If you had only intention to call for the AGM, you could not have written all this. So you see, your particular intention is something else. So you are not holding any AGM. Maybe not relevant in this part, but I am showing it. Now, my lord will kindly see, this was the letter. This is of 2021. They could hold in 2022. After 22, I remember there is no COVID. 23 passed, 24 it has passed, there is no AGM was held. Now what the association will do? They cannot go ahead, they cannot run this association, and these members were really frustrated. There has to be an AGM. Now, in order to that, kindly see at page 105. This is the cause of action, how it started, which will your lordship will find at para 9 of the plaint. Right? Para 9 of the plaint. See para 9 first. Then I will show that. At page 72. See para 9. Eight long years they did not convene the AGM. Your Honor will kindly, your Lordship will kindly note down. 8 years. See 9. That on 33/2024, two of the joint secretary that are different number 2 and 5 of the executive committee for the session 2015-17 of the plaintiff association has circulated a purported communication among the members of the plaintiff association inter alia convening a meeting of the members of the Plaintiff Association on 3/4/2024 at 6 a.m. to discuss about the fate and issue relating to formation of new committee. Now this your lordship will find at page 105. Kindly see 105. The two joint secretary addressing to the esteemed members of the association. Hope all are in good health. You are hereby informed that a strong resentment among the members have been observed on the way of functioning of the association activity and especially non-convening of the AGM for the last 8 years. In view of this, it is decided to meet at the conference hall of the Chief Engineer office premises on 3/4/2024 at 6 p.m. to discuss about the fate and issue related to formation of a new committee of the association and various welfare issues of the member of the association. All members are hereby requested to make it convenient to attend the meeting on the said date and time. Those members who are unable to attend the meeting due to ensuing election, they can attend the same through VC or extending the support by putting the respective signature in the prescribed attendance sheet circulated to them. Now, these two secretaries, joint secretary, have issued this letter to the all the members. Now, your lordship may ask me, or I am putting a question, whether these two are empowered or not. These two has to call by virtue of the constitution whether they are empowered or not to issue a notice calling for an AGM. If AGM is not being held for 8 years, then extraordinary general meeting has to be called for. Whether it is provided, let us now see. So it will be easier to connect. See page 96 again. The locus of these two, this joint secretary, 96. Kindly see 96. Before going to 96, kindly see 71 of their plan, Everment. Para 6. Kindly see para 6. '71, para 6 of the plant. That, see, Hitan Kolita, who was the General Secretary of the session 2015-17 of the Plaintiff Association, had also superannuated on 30/11/2023. And at present, the post of General Secretary of the Plaintiff Association is vacant. Now, if it is vacant, then what provides the Constitution? What is there in the Constitution? Who will act on behalf of the General Secretary? So, if your lordship kindly turn to page 96, 96, see 11.2 of 96. B, 11.2b. 11.2b. The General Secretary shall be assisted by the Joint Secretary in the manner decided by the State Executive Committee or the President. One of the Joint Secretary shall perform the function of the General Secretary in the latter's absence in any manner like retirement or resignation from the Assam Engineering Public Works Department service. Now, if you see 11.2d, the General Secretary shall convene all meetings and record the proceeding of each in a book kept for the purpose. The proceeding of the meeting shall be signed and proceedings shall be confirmed in the following meeting. So now, in absence of General Secretary in the plant, so the Joint Secretary will act on behalf of the General Secretary. And accordingly, on 30/4/2024, if your lordship again look into 105, again look into 105, look into 105, the Joint Secretary has issued this. So, virtue of this constitution, under 11.2b, in absence of general secretary, the joint secretary will act. And when the general secretary is not there, he will perform the function of the general secretary. And accordingly, for 8 years, there was no AGM, so they have to call an extraordinary general meeting. Now, for extraordinary general meeting, my lord, there is a quorum. There is a quorum, which your lordship will find 14.3 at 99. Kindly see 99, the quorum. 14.3. 14.1. No, kindly see 99, 14.0, general body. 14.1, general body of the association shall comprise all members of association. An open session of general body shall generally be held once in a year after the president for the term for next term has been elected. However, the general body meeting may be convened at per convenient time as decided by the president. Number 14.2. The other members of the office bearer of the State Executive Committee shall be elected by the general body. The report of the outgoing State Executive Committee as well as so and so during the next term shall be placed before so and general body may resolve further action so. 14.3. The quorum for the AGM meeting and the extraordinary general meeting shall be 180 respectively. If no quorum is formed, the general body extraordinary meeting shall be adjourned. So this is the quorum. Now your lordship has seen the AGM every year it has to be held. Now here is a case for 8 years they did not hold it. So having no alternative, by virtue of that letter, which is empowered by provision of the constitution, the two joint secretary in absence of general secretary has issued this notice at page 105. And accordingly, there was the discussion for taking the discussion is in respect of formation of a new committee, which will be held on 3/4/2024. Your lordship has seen that. So, in pursuance to that, 450 members attended the meeting, and in pursuance and some were on virtual. In pursuance to that, this committee was formed. Now, I'll show your lordship the committee, the minutes of the committee at page 21. Kindly see 21. See 21. Minutes of the extraordinary general meeting of Assam PWD so and so. Members present. So as per enclosed annexure A. So we have annexed all those members from page 25 up to 60, 59. Up to 59. All the members. 59. 450 plus VC. Now kindly see the wording of page 21. How the meeting was conducted and what is the result of the meeting. Since the previous committee, General Secretary has retired, Engineer Nipendra Bhuya, the Joint Secretary of the previous committee, welcomed the engineer fraternity of PWD Assam, coming from different part of the state, was present physically and through video conference. He explained the non-functioning of the previous executive committee and non-convening of the AGM since last 8 years. The general body emphasized their views and need of the formation of a new executive committee as most of the members, including the president and general secretary, has already retired. The members of the extraordinary general meeting have raised their unanimous views for urgent requirement of a new committee to propagate the basic issue of the members which they are facing by them during the service period. By considering all aspects and activities of the previous committee, such as not convening of the AGM for last 8 years, which has been considered to be the key point for formation of new committee, by convening today extraordinary general body meeting, in view of this, some decision has been taken by the senior members presented on the dais namely Engineer Abani Sharma, so and so, by responding the views offered by the members present. Now, these are the views they said in support of the formation. Your Lordship will skip this and see kindly 23. Kindly see 23. By considering, so the views was expressed, by considering the views expressed by the members as above and views offered by engineers from different corners of the state, expressing the consent for formation of a new committee, today's extraordinary general meeting unanimously passed the following resolution. 1. A new committee has been formed as per Annexure B enclosed herewith. It is unanimously decided to comply with the government rules and regulations as per Personnel Department dated 1991. General body has unanimously proposed and elected Bhavan Sharma as the president, Nipen Bhuya general secretary of the Central Committee. As per the approval of the members, portfolio of the executive members has been announced by General Secretary and the same has been accepted with huge applause. So this is these recorded. They decided the committee to be formed and accordingly committee was formed. One thing I just want to show before your lordship that the president, electing of president is of different category altogether. Here, president along with the members, the association was formed. The president, there has to be. So for other members, if you don't hold an election also, somebody may propose it, there may not be a election, there may be a selection. So for other members, but president, there has to be election. In this case, president, there was no election. Let us make very point. President was not elected. There has to be election. But even if the president is not been elected, the other members will continue. In what manner the president has to be elected? Kindly see this. At page 94, see page 94 of the Constitution. 94. See 94, election to the post of president. The executive committee, the executive committee shall prepare a list of 3 or more names arranged in order of preference. Lordship got it? From among the member of the association for election for the post of president for the next term. Such list shall be sent by post email to each member of the association to respective zone at least 2 months before the date selected for the AGM. In absence of unanimous candidate for the post of president, the election of the president should be held by ballots by all the members of the association. The ballot papers shall then be issued to all the members to the general committee. On being casted votes by the members, the sealed ballot papers shall be dispatched to the association headquarters as per program and instruction prescribed for the purpose. The counting of the ballot paper and declaration of result shall be done at the association headquarters. Election shall be by a simple majority. The election of the post of president shall be completed at least 1 month before the general body meeting of the association. So that's the procedure which has been laid down for election. Normally what happens, which my experience in some of the clubs or some of the association which are being formed, there may be a nomination of 3 posts of one post, there may 3% may contest. 3% may contest for the president. Now contesting the president, 2 may not. It happened in the extraordinary general meeting. There are 3 candidates with an understanding that 2 will not contest. So the president is being selected. So only this clause will apply when there are candidates. For the post of president, maybe 3 posts, then all this procedure has to be followed. Normally it happens, my lord. I have seen my experience that contesting 3% for the post of president. When in the extraordinary general meeting they said these are 3%. Now these are understanding that no, will not contest. Let A be the president. Will not contest. Then this provision of 94 will not apply. 94 only will apply when there are more candidates. then this procedure has to be followed. Now your lordship will kindly see. Now let us, for an argument's sake, let us see that president should have been election should have been taken place. Whether the committee could have functioned, which is laid down at 99. Kindly see 9914.2. See 9914.2. 14.2. The other members and office bearer of the state committee shall be elected by the general body. The report of the outgoing so and so. So the other members and office bearer of state committee shall be elected. Once you are elected, this is the committee which has been formed, and that's the association. They recognize 450 members. My lord, the situation would have been different. There are 80 members, even there is a quorum, but here is a 450 members who are present. Now, if your lordship kindly see, this is a position. Now, we hold the AGM in pursuance to the letter which was circulated on 30/3/2024, and on 3/4 it was held. Once they came to know that we have informed to all the esteemed members on 30/4/2024, then this president become active. This president has become active. Kindly see at page 107. Kindly see 107. See 107. My lord, 8 years this president was sleeping, and he gets active once a notice was issued to all the members. He gets active, and even in spite of letter of 12/6/2021, where a promise has been made that we'll hold the AGM end of 2022, he doesn't do it. I am telling your lordship the motive is something else, and your lordship says the resolution which has been taken, all the intention was that nothing was done by this association for long 8 years. They were sitting idle, and their statement in the plan is that we could not hold because of the COVID. When was the COVID? COVID was March 2020, and 2022 you have issued. By that time there was no COVID. 2022 there was no COVID. See 107, his letter, 31/3/2024. 1 day after we have issued on 30, he became active after 8 years, 31/3/2024. See, it is for general information to all the esteemed general members of Assam PWD Engineer Survey Association that the AGM is scheduled to be held as per the date and time mentioned below with the following agenda. So, my lord will kindly see, number 1, formation of new executive committee. Number 2, miscellaneous date 9/6/2024. Kindly see this signature who has done it. The President, Pranab Kumar Rava. So that is why I am raising the issue. Who is Pranab Kumar Rava? Whether it is nominated or decision has been taken by the State Executive Committee. Self-styled president in charge and files a suit. And a democratic process where the election has taken place, he wants to stall it by filing a suit, and with great respect to the learned trial court, injuncted that please do not proceed. This executive committee not to give effect with the executive committee, and a committee which is running by self-style, he is running that committee, and our is a democratic process has started, elected, and there is an injunction which is against us. So that is why we were before the learned trial court and appellate court saying that this is what has been done. Now, and pay 107, how the president can call for. Let us for an argument's sake, president has called for. Whether by the constitution he can call for. That is against the constitution. Kindly see 96, which I have read, 96, 11.2d. 11.2D. So there are two league of argument. One is that he didn't have the authority, number one. So he could not have called this notice, number one. Number two, he did not have any authority to issue a notice because in view of page 96 11.2D, which I have shown, in absence of general secretary, only the joint secretary has to call for a meeting. So in that view of the matter, anyway, he could not have issued this notice. Now, how they came, because there was a newspaper which at page 113, so that will also indicate that this is elected body. 113, sir, kindly see body formed by a newspaper, Assam Tribune, body formed. Lordship got it?
Yes.
8 years. After a gap of 8 years, so and so recognized, so and so. So after this, they came up before this court and challenged all this. Basically, 3/4/2024. If your Lordship kindly see the prayer which they have sought for in the plaint is page 81. What is the prayer they made? Kindly see the prayer. Prayer a decree declaring that a defendant number 25 has no authority under constitutional plaintiff to issue a communication dated 33/2024 and also to convene a meeting of the members of the plaintiff on 3/4/2024, which I have shown prima facie. At least I have shown that what authority this joint secretary had. Number B, a decree declaring that a meeting of the some members of plaintiff which was held on 3/4/2024 under the guise of EOGM and wherein office members were elected and committee were formed for representing the plaintiff person illegal, null and void. Admitted position that there is a committee was formed. Now they sought for injunction, a permanent injunction restraining defendant, because not to give effect with that EOGM which was held and a committee was formed on 3/4/2024. That's the prayer which they have sought for. And the Order 39 Rule 1 and 2, if your Lordship kindly see Order 39 Rule 1 and 2 at page 128, that the injunction application which they have filed at page 128 is a prayer. 128 is the prayer. Order 39 Rule 1 and 2. It is therefore most respectfully pray the Honour may please to admit, exempt prior issuance of notice so and so, be pleased to restrain the opposite party, the main agent servant, claiming through them by way of an interim temporary injunction from giving effect to the formation of committee formed in the so-called extraordinary general meeting held on so and so, also from acting upon the resolution taken first in so-called extraordinary general meeting and for representing acting on behalf of the petitioner so and so. So they are asking their prayer for permanent injunction with their sort of virtually is the same where they are asking for an injunction, temporary injunction, restraint. Now the order passed by because your Lordship has seen the order of the appellate court has not expressed any mind. Lordship has seen that, only a submission recorded. Kindly see the order of the learned trial court. 132 it starts. And see para 5 of the learned trial courts which starts from 132. Para 5, yes. See para 5, 135. 135. See para 5. Since it is a prayer filed for passing an order of interim injunction, this court finds it justified to discuss the three golden principles of granting an injunction in the backdrop of the pleading and documents submitted before it. The court finds caveator opposite party number 5 represents himself through his learned counsel and the court has given the caveator counsel a patient hearing. Very good, my lord. Patient hearing is given is good, but there is no record of submission by the caveator. All this point, I have not seen at least. Submission. There is no submission which I find. So now the 139, 138. Kindly see the last from para 11 last three line at page 138. Last three line 11 before 11 last three line. The act of the opposite party in the reconstitution of the committee are not tenable in the eye of settled provision of constitution. My lord, of the petitioner. He makes, my lord, with the learned trial court saying it is not tenable as per the constitution. What remains? Then you decide. Today, my learned friend may argue that it is on third. So why they are coming? Go back. But you have taken already a decision. The act of the opposite party in reconstitution committee are not tenable in the eye of the settled provision of the constitution of the petitioner. Given the facts and circumstances presented, there is a compelling argument for moving forward with a trial. Opposite party have engaged in unlawful tactics to take control of the petitioner association, thus infringing upon the legitimate right of his member to participate in a free, fair election. Now kindly see 139. Under aforesaid sound, the court has meticulously analyzed the facts, conclude the three fundamental principles, granting of so and so, so and so. So ultimately, the order was passed to the effect, page 140, para 15. Hence, an interim injunction is passed against the opposite, restraining them, their main agent servants, claiming to by an interim injunction giving effect to the formation formed in the so-called extraordinary meeting, and also from acting upon decision in so-called extraordinary meeting, so and so, and for representing them from acting on behalf. This order means shall be enforced, so and so, so and so. So it is a verbatim of clause the C of the prayer which they have made. Exactly same. A permanent injunction you sought for, and it's a verbatim of the injunction which interim injunction which has been granted. So this is my case. So my humble submission before your lordship is that it is a fit case. Your lordship will kindly interfere with the order passed by the learned trial court, and there is no reasoning passed by the appellate court. My prayer before your lordship is a democratic process and election has taken place. So my prayer is let it be continued. There may be two issues. One, let it be continued and your lordship will decide. Next is that let this committee which is democratically is elected, let it continue and let it go before trial court. Right? And the learned trial court, my respectful submission, may first decide the point of maintainability also. Either your lordship decides, keep this matter here, and let the democratic process of the election has taken place, let them continue, because they doesn't have any locus on the point. Let it be continued, or sends it back to the learned trial court, and the elected body should continue till it is decided in learned trial court, and maintainability point should be decided. In this case, I'll just draw quickly two judgments of the Supreme Court, because there is a judgment which has been, I have pointed out, the Wanter and Antox. Wanter and Antox, the power of the appellate court is very limited, saying that you please do not substitute unless it is arbitrary perverse, paragraph 14. But there is one judgment of the Supreme Court, that Ramdev Food Products 2006 8 SCC 726, one line I will show it. Wanda and Tox has been discussed in paragraph 126. Kindly see 126. 126. The grant of interlocutory injunction is in exercise of discretionary power, and hence this appellate court will easily not interfere with it. However, the appellate court will substitute their discretion if they find the decision has been exercised arbitrarily, capriciously, perversely, where the court has ignored the settled principle of regulating the grant of refusal of injunction. This principle has been stated by this court time and again. Wonder and Tox and had been discussed. The appellate court, 127. The appellate court may not reassess the material and seek to reach a conclusion different from the one reached by the court below if the one reached by that court was reasonably possible on the material. Appellate court would normally not be justified interfering in the exercise of discretion on appeal solely on the ground. If it had considered matter at the trial stage, it would come to a conclusion. Now see 128. Most important. However, in this case, the courts below proceeded on a prima facie misconstruction of document. They adopted and applied the wrong standard. We therefore are opinion that a case for interference has been made up. So misconstruction of documents, the court totally ignored the constitution. This should have been looked into by the learned trial court. This is our case. No, my lord, this is my submission. My learned friend is here. I'll take just a leave because there's other matters also. So my learned friend will have the opportunity, and my learned friend is here to give a reply also. I am deeply obliged now.
Yeah, please, Lord. Lord, I was the plaintiff before the trial. Issue involved in the suit is as regards the election of the Assam PWD Engineers Association. Now, before taking your lordship to the constitution, and it is the constitution within which these elections and everything has to be held. Now, what is the process of election? Well, for selecting the post of the president prior to the date of election, first of all, date has to be names has to be called from the zones. There are around 9 zones. So the executive committee of the elected association, they will ask for the names from the zones, that you please give me the zone number. Now the zones will send the names in seriatim, say 1, 2, 3, 4 in order of preference. Therefore, and those names, my lord, will be kept under the seal cover. And that is provided, my lord, if your lordship kindly turns to the constitution at page number, my lord, 94, my lord. Page 94. Have you got it, my lord? So this 94 says that election to the post of president. So these names, which it has to become 2 months prior to the date of election, and those names will be kept under the seal cover, and in the date of the election, those will be opened, and whoever gets the maximum number of preference, he will be selected as the president. Meaning thereby, my lord, the process of selection of president has to start 2 months prior to the date of the meeting. Now, in the constitution, my lord, I will take your lordship through few points, my lord. Lordship will kindly turn to page 88, my lord. Because what are the functions, how this society will function, this is also given in the page 88, my lord. You got to clause 1.2. Page 88, clause 1.2. The supreme authority. The supreme authority of the association shall rest in the general body consisting of members of the association assembled in an ordinary, extraordinary general meeting. This is important, Lord. The affairs of the association. The Lordship will kindly mark down. The affairs of the association shall be managed and conducted by the state executive committee, which shall be the chief executive organ of the association. Then your lordship will come to page 93. Page 93. Clause page 93, clause 8, outgoing state executive committee. First we will read that 3 lines from below, my lord, except the president.
93 clause?
Clause 8, 8.1, 8.1, 3 lines from bottom, except the president.
Yes.
Except the president, the election of the office bearers and members of the state executive committee shall be held in an open or extraordinary session of the general body
from amongst the members only. Now, why this except president? Because, my lord, I have already shown your lordship that how the president is to be elected is that prior 2 months. So, therefore, it says that except president, how the other members are to be elected. Then your lordship will turn to next page, my lord, page 94. That relates to election of president. Then your lordship will come to, my lord, page 95, 10.3. Page 95, clause 10.3. The election of the members and office bearers of the State Executive Committee for the next term shall be done as per the program fixed by the outgoing State Executive Committee. That means, my lord, the committee which is in existence, that will choose for the next term, that when the election is to be held. Then we'll come to, my lord, 10.5. 10.5 says a notice of 7 days will be necessary for convening a meeting of the State Executive Committee, but the President shall have the power to convene an emergent meeting of the committee on short notice. Now, my lord, it says that a 7 days notice has to be issued. After issuing that 7 days notice, that State Executive Committee will assemble, and the State Executive Committee will take a decision when the next election will be held. But in this case, my lord, nothing has been followed. Then your lordship will come to 10.7. In all meetings, 10.7. In all meetings, the president shall conduct the business. In absence of president, one of the vice president, or in his absence, any members of the executive committee shall be elected to preside over of the meeting. So it says that in absence of the president, the vice president will have the power to preside over the meeting. Then your lordship will come to next page, 96. 11.1. President. The president of the association shall be the head of the association, and in case of absence of the president, one of the vice president will exercise the powers of the president. Now, my lord, an argument has been done that there has to be an authorization by the committee that the vice president has to be nominated as the president. But here it says, my lord, the president of the association shall be the head of the association in absence of president. My lord, suppose the president retires. In absence of the president, one of the vice presidents will exercise the powers of the president. My lord, this sentence precedes the subsequent sentence which says there has to be a nomination. Suppose, my lord, there is no nomination, the president retires. My lord, what will be the fate of the association? In that case, my lord, taking that situation in mind, this has been put that in absence of any president, the vice president will act as the president. Now we'll come to 11.2. This is important, my lord, because I'll show your lordship that the appellant petitioner before your lordship doesn't have any locus, because he is portraying himself to be the general secretary of the association. Now, before going to that, let us see what are the powers and functions of the general secretary. 11.2, my lord. The general secretary of the State Executive Committee shall function under the direction of the president and the State Executive Committee. That means the general secretary will function under the direction of the president. The general secretary shall be assisted by the joint secretary in the manner decided by the State Executive Committee or the president. One of the joint secretaries shall perform the functions of the general secretary in the latter's absence in the manner like retirement, for instance. But now, if the general secretary has retired, the joint secretary will perform the duties of the general secretary, but that would be subject to supervision of the president or the State Executive Committee. The general secretary doesn't have any independent power, my lord. That is always subject to supervision of the president or the State Executive Committee. That is 11.2 A and B, my lord. 11.2 A and B. So next page 97, my lord. Clause E. The general secretary, clause E, my lord, the general secretary shall perform other duties as assigned to him by the State Executive Committee and the president. Now here is a case where the joint secretary is acting as the general secretary and they have convened a meeting. Now, if that be the case, my lord, there has to be an authorization from the State Executive Committee and the president. Whether there is anything, nothing. Then clause G, my lord. The General Secretary shall conduct the correspondence of the association and sign letter association under the direction of the committee. So even if that notice of the 30th March is issued, there has to be a direction from the committee. Now these, in brief, my lord, these are the points under which this case is related. Now this is an election which was held, and the committee which was formed, that your lordship will find at page number 102. 102, man. So, my lordship found the certificate certified that the following persons have been elected as office bearers of so and so for the session 2015 to 17 in the election held on so and so at the institute of so and so. Now, the president Dilip Kumar Phatak, he had retired. Vice President 1 and 2 have retired, and 3, the Pranav Rava, he is the present president in charge. Then the number 3, General Secretary, he has retired. Now number 4, Joint Secretaries, this Subroto Bora and 2 and 3, my lord. You got it? This 2 and 3, they are the Joint Secretary. Now this is the committee, my lord, which is the legally elected committee and which is continuing as on date. But they, in order to scuttle the powers of this committee, that meeting has been held in an illegal manner. Now, this is the committee which has been formed. Now, these two persons, my lord, who are, one of the person, this petitioner, he is at serial number 3. What you got it, madam? Serial number 3, Nipendra Bhuyan. This is the petitioner before your lordship. Now, in this committee, after the, my lord, superannuation of the president and other vice president, the vice president at number 3, this Pranav Kumar Rava, he is discharging his duties as president in charge. 11/2023, General Secretary was there. After retirement of the General Secretary, now these Joint Secretaries, they will be discharging their duties at the General Secretary. But that would be subject to supervision of the President. Now, this is, now their case is that next page 103. Now, lordship, you see, this is in the letterhead of the petition of this Aviators Association, my lord, this PW. On the left hand side, lordship will see, my lord, president in charge, Pranav Kumar Rava, lordship found, my lord. Down below, vice president, so general secretary, joint secretaries, this Santanu Kumar, Niven Bhuya and Subrato Bhuya. This number second one, he is the petitioner before your lordship. Now, this is a document of 2021. Now, their case is that this Pranav Rava has been intimidating as the president of the association. Now, if that be the case, this document was issued in 2021. When this document was issued in 2021, they did nothing. And this is a printed letterhead. In the printed letterhead, it is written as president in charge. So, when this letterhead was printed and it was being circulated, at that time they could have raised this objection, my lord. Meaning thereby, my lord, they knew everything. Now, for the purpose of this case, the story has been cooked up that this president is intimidating as the president in charge is intimidating as the president in charge. So, at 2001, 2021, nothing. Now, meeting was for, this committee was for 15 to 17. Now, from 17 to 23, they were under deep slumber. All of a sudden, they wake up from the deep slumber, and within 2 days' notice, the meeting was held. Now, what was that earth-shaking urgency, my lord? That a meeting has to be held at a short notice of 2 days. Now, these, my lord, so therefore, my lord, they cannot blow hot and cold at the same time. On one hand, it is your document, you are there, you not raise any objection in the 2021. Now in 2023, you will come and say, no, this petitioner is impersonating. This president in charge is impersonating as the president in charge. He is not the president. So therefore, my lord, by virtue of the principles of estoppel, they are now stopped from raising this issue at this belated stage. Now your lordship will kindly come to the notice. Page 105. Page 105. Page 105. Now your lordship will see this is a letter. Page 105. And for a moment, just if your lordship comes to the earlier page, page 105, I just skipped one thing. At page 104, at serial number 11, my lord, the lordship will see, your lordship finds the name Bhaven Sharma. Lordship. Now, these gentlemen, he is the new president of this illegal association which has been formed in the meeting T4. Now, if he is the president and the petitioner before your lordship is the general secretary, now the president, this general, he may say that no, I was not aware of this thing. If you are not aware of this, your signature is there, your president has knowledge about this thing. If your president have knowledge about this association, about this Pranab Rava working as the president in charge, how you can come and say that no, Pranab Rava is not the in charge? Now, lordship will turn down to 105. 105, my lord, this is not a notice. I would say, my lord, this is a letter. Now, in this letter, who has issued this letter? This Nipendra Bhuya and Subroto Bora. And Nipendra Bhuya is the petitioner, and down you see 33 to 2024. On 30th, this letter is being issued. And the contents of the letter, your lordship will see. I will not trouble your lordship with the entire thing. From the middle, at 6 p.m., if lordship got at 6 p.m. Now, what was the agenda of the meeting? To discuss about the fate and issue relating to formation of new committee of the association and various welfare issues of the members of the association. Meaning, there was no agenda in the meeting that the new committee will be formed. Why? What was the agenda? To discuss about the formation of the new committee. Now, this notice, which purportedly has been issued by this joint secretary, whether this joint secretary was authorized by the president or the state executive committee to issue this notice, my lord, because the constitution says that the joint secretary or the secretary, in absence of the general secretary, the joint secretary will be discharging the duties as a secretary. But the secretary shall always be subject to the supervision of the president or the executive committee. Now, while issuing this letter, there is not even a single whisper that the outgoing committee had authorized these two gentlemen to issue this notice. Now, on 30th, this notice is issued. And when the meeting is called, my lord, the meeting is called on 3rd of April. The lordship will see the dates. Within 2 days, 30th March is a Saturday, 31st March is a Sunday, Monday on Tuesday, and 3rd of April. Only 2 days notice. And this is not an association of handful of persons, my lord, who reside in a society, building society or something. My lord, these are the members of an association who are spread over the entire state of Assam. And moreover, in view of these ensuing elections, my lord, these employees are employed in the election duties. Even ignoring all those things, my lord, this meeting is called. Now, this about the election, the existing committee was already discussing the matter, because in the plaint at page 43, at page 73, before taking this document, I'll just try to take your lordship at page 73 of the plaint. And the president, this notice about the meeting, it came to know only after it was published in the newspaper. The meeting was held, committee was formed, nothing was circulated, everything was kept in a hush-hush manner. Now, in para 10, my lord, we have stated, I'll just read down, page 73, that after the aforesaid communication dated 30/3/2024 came to the notice of the president of the Plaintiff Association on 1/4/2024, when the same was circulated in WhatsApp group of the members of the Plaintiff Association, the president by its communication dated and informed the said two joint secretaries of the Plaintiff Association that the AGM of the Plaintiff Association is scheduled to be held on 9/6/2024 Sunday as discussed. Well, we had already discussed that the meeting will be held on 9th of June. So if they knew that the meeting is going to be held on 9th of June, and we have also, now your lordship will come to page 106, because 105 if there in there is their notice. Now, as the matter was already discussed with the joint secretary, so what the president did, the president had written to the page 106, madam. Because for the purpose of holding the meeting, some accommodation will be required. That is why the president had requested the special secretary that page 106, madam. Lordship got it on top, and it will see letter dated 33/2024. 106, madam.
Yes.
33/2024. This is the letter. Now, who has written this letter? Down below, your lordship, Pranab Kumar Abba, President, so and so, so and so. Now, this letter was issued on 30th March, and it was addressed to special commissioners and secretary to the government of Assam. Subject: permission for holding of annual general meeting of Assam PWD at PWD Convention Center. Now, we have written to the special secretary that please allow us to hold the meeting in the PWD Convention Center. And on the top of this document, and handwritten, your lordship, is OSE 1/4/2024. Lordship got it, my lord, it is handwritten. So that means when it is placed before the secretary, he keeps a note. So he has given that. Then on 31/3 at 107, we have circulated a notice that the meeting will be held on 9th June 2024. 9th June 2024. Now, why this notice was issued? Because it was already discussed that meeting will be held on 9th June. So, we have sought permission from the Special Secretary, Government of Assam. On 31st, a notice has been issued. Now, a notice has been issued. Now, the question has also been raised and an argument made that the President had no authority to issue the notice. Now, these two joint secretaries, when they are not functioning in favor of the society, my lord, they are going against the interest of the society. The president has no other option, my lord, because the president has to save the society. So the president issues a notice dated 31/3 informing all the members, and this notice, my lord, is in the letterhead of the association. The letter dated, my lord, which was issued on 30th March, your lordship will say this is just a letter on plain paper, my lord, nothing, no letterhead, nothing. Page 105. Just compare this page 105 and 107. 105, it is in a plain paper, my lord. So, if it is the association calling for a meeting, it should have been in the letter of the association. But whereas at page 107, your lordship will see it is on the letterhead of the association, and it has been rightly issued by the president. Then at next page, 108. Next, please, 108. But it is not that the president is not informing these two gentlemen who have issued the notice. Please, 108, your lordship will see. On 1/4, this 108. On 1/4/2024, the president had also written to these gentlemen that, I'll just read out, hope the correspondence will find you Gulen. In response to your communication dated 30th March 2024, on the matter of so-and-so, which came to my notice a short while back on 1/4/2024, I do express my solidarity to strengthen our esteemed association for upliftment of its members. Therefore, on the strength of resolution taken in several executive body meetings and in response to requests made of the members throughout the state, the AGM is scheduled to be held on 9/6/2024, and accordingly permission to hold the AGM at the PWD Convention Center so-and-so was sought for by the communication made on the occasion of the concerned authority dated so-and-so. You might be agreeing that holding of AGM meeting AGM during the period of enforced MCC, that is Model Code of Conduct of Election Commission of India for Parliamentary Election 2024 shall be quite unfair. So, my lord, we have also informed them that meeting is going to be held on 9th of June. Now, in spite of all these things, why not a meeting has been held? Now, if the meeting has been held, now what decision has been taken in the meeting? Lordship will kindly come to page 21, what is the decision of the meeting? Page 21. Page 21. Minutes of the extraordinary general meeting body so and so held on 3/4/2024. So this is the minutes. Now down below your lordship, in support of the formation. Lordship got it. In support of the formation of new body, different members have expressed their views and support in front of members of so and so. Now against each dots, your lordship will see that the names of various engineers who supported, their names are written. First number, second serially. Next page also, page 22, your lordship will see all the names are there. Lordship found it, my lord. Against each dot, your lordship will see there are some names. But only in the second dot, your lordship will kindly come. Page 22. Second dot. Now, it says that Chief Engineer PWD NH Works. Now, my lord, in a meeting, a resolution has been passed. Well, whoever says what has been recorded, but accept the name of this gentleman. Now, for the sake of my lord query, satisfying our inquisitiveness, that who is this gentleman? Everybody is written that Manoj Das, Nipen Bhuya, so and so, this. Why the name of this gentleman is not there? Now, it is in public domain, lordship may see that who is the chief engineer of PWD, so and so, so and so. It name comes that one Mr. Debojit Das is the chief engineer. Then, my lord, in the, my lord, this Osim, in the dot against Osim Chakraborty, in the page 22, because the purpose of taking your lordship through these, my lord, lines are that your lordship, because in corporate law, my lord, there is a my lord, conception that lifting of corporate veil. Now, in this case also, your lordship will has to lift the veil and see what is the main motive behind the meeting. The main motive behind the meeting is not for the, my lord, welfare or upliftment of the members of the association. The main motive behind holding this meeting is something else. Now, what is that motive, my lord? Lordship will see, my lord, that here Osim Chakraborty expresses, lordship got it, page 22, 1, 2, 3, 4, 5, 6, 7, 8, number 8 from top. Osim Chakraborty. Now, this Osim Chakraborty, he says something. And in this paragraph, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10th line from top, as per knowledge. As per knowledge, in the middle.
Yes.
Right. As per knowledge, there is still one case pending against one of the member of previous committee, writ appeal number 244/22, which was filed without any approval from previous executive body. He made an appeal to members to take decision to withdraw the said litigation immediately by taking appropriate steps by the new General Secretary for withdrawal of the said case at the earliest. Now, my lord, what is this writ appeal 244? Because this is, my lord, downloaded from the this lordship can, this is from the High Court website, your lordship can check out. Lordship has found, my lord, writ appeal on tab, registration number 244/22. Now, who is the appellant in the writ petition? My lord, the caveator, the Assam PWD service engineer. The caveator, we, in this case, they are the petitioner in this writ petition. And respondent number 1, Debojit Das. Lordship found and the respondent's advocate, that is Debojit Das. Now, your lordship will connect the dots. The name of, at second page 22 second, the name of this gentleman is intentionally not disclosed. By designation, he is written PWD Chief Engineer. Now, it is in the public domain. Lordship can ascertain who is the Chief Engineer PWD NH works. My lord, I have given a copy. It is Deposita. Now it also says, my lord, we will keep in mind what was the notice. Notice was for formation, which was issued on 3rd of March. This notice says that we will assemble and discuss about the formation of the new committee. Now here, not only a new committee is formed, it moves far away behind that and takes a resolution that, see, this writ appeal has also to be withdrawn. And what is this writ appeal? This is the person. No, my lord, the purpose behind this meeting is not the formation of the association or formation of the executive committee. The purpose of this meeting is to break this association so that this gentleman could put forward his person and before this court and say that no, we have taken a resolution, we will withdraw this case. And what is this case, my lord? This is a case which relates to promotional benefits of this gentleman. Now, if he can get this writ appeal withdrawn, my lord, his road will be clear. There will be no thorns in his road. So that is the purpose of holding this meeting. Now, the next page 23, lordship will see. Clause number 10. The committee, lordship got it, page 23, clause 10. The committee expressed its concern over the issue of initiation of litigation against its own member, leading to financial loss as well as loss of reputation of the association. Accordingly, it is unanimously decided not to initiate litigation against any of the members of the association. In case of arising any issue, attempt shall be made to resolve the same within the floor of the association. Today, the meeting also resolved to authorize General Secretary of the association to represent, General Secretary means the petitioner before your lordship, authorize the General Secretary of the association to represent the association in all pending litigation before any court of law or any future litigation wherein so and so is a party, and also assigns on behalf of association relating to any court cases. The committee has authorized so and so to take immediate necessary steps for withdrawal of any litigation filed by the previous association that is pending against any of the members of the association. Now, the main motive behind this election and holding of this election and selection of body is that let us form a body which will support this gentleman's case, and that gentleman through backdoor will get these cases withdrawn. Now, these gentlemen, my lord, I am reporting upon a judgment of 2019-12 SCC 275.
But
2019-12 SCC 275, para 22. Now, why I am referring to this judgment? On the top of the judgment, but this, my lord, first page, lordship, see Ajit Kumar, top on Ajit Kumar Bhuya versus Deposita. Now, for his promotional benefit, he somehow managed everything and he jumped over all his seniors. So ultimately, it led to the honorable litigation reached the honorable Supreme Court. Now, what words the Supreme Court issues, or what word the Supreme Court says against these gentlemen? This is not my words, my lord, because this is a reported judgment. That is why I am referring to your lordship. Your lordship will kindly read para 22. Page 8, my lord, in para 22. What you got in? Yes. We thus find that the findings of the learned single judge to the effect that the encadrement of the respondent number 1 to the post of executive engineer was illegal, not only on the ground that he was ineligible for consideration as he had put it only 3 years of service, but also for the reason that there were only 10 vacancies and not 13, and therefore the respondent number 1 could not be promoted at all, are without blemish. We are also in agreement with the finding of the learned single judge that the respondent number 1 was guilty of committing fraudulent acts in getting his promotion to the post of executive engineer out of turn and contrary to the service rules. Even the division bench in the impugned judgment accepted the aforesaid proposition in para 20 of its judgment. It is quoted, my lord. It is no doubt that the promotion of the appellant to the post of so and so and the consequent encadenment is contrary to the service rule, since he had not put in the required service of 5 years in the eligible promotion of post of so and so. The condition in promotion order that the officer over the other so encadred should be in the lowest position till the seniority comes to the position and appears an untenable condition could not be attached to the promotion of the other services. There appears to be compounded illegalities. There appears to be compounded illegalities. The promotion may be illegal, so much so that the condition stipulated is also illegal. Promotions have to be granted according to the circular. Then your lordship will come to down below page para 26. This is more important, para 26. Having regard to the circumstances with the respondent number 1 was given promotion to the post of executive engineer by creating an ex-cadre post, and thereafter the manner in which he was encadred to the said post by stretching the number of vacancies against the record speaks volume about the manner in which undue favor was shown to the respondent number 1. One has to keep in mind that at that time he was working as the officer on special duty to the chief minister. These facts reflect clear manipulation of the system at various stages to give out-of-turn promotions to the respondent number 1 by bestowing undue favor. With such flyover promotions, respondent number 1 parachuted from assistant executive engineer to superintendent engineer by bypassing many senior colleagues in the cadre of assistant executive engineer who are still stagnating in the same cadre. Now, this judgment, my lord, speaks volume about the conduct of this gentleman. Now, having said all those things, my lord, and they have also, my lord, exercising his official position, managed to gather the signatures of those things. Now, my lord, my respectful submission before your lordship is that when they knew very well that meeting is going to be held on 9/6/2024, why don't you participate in the meeting? What was that earth-shaking urgency that on 30th of March we will give a notice and on 3rd of April we will hold a meeting, and the purpose of meeting was not formation of new committee, was discussion of new committee, and in that meeting we will not only form the new committee, we will go beyond that and we will take resolutions which does not help the association but helps some other individual. So therefore the purpose of this meeting was not for benefit of the members of the association, but it was for a personal benefit of a particular member of the association, and it was not at all bona fide, it was perpetuated by malice, it was malafide. My second leap of argument would be, my lord, what is the locus of this gentleman to prefer this appeal or revision? Because this, what the order is, my lord, the order of the trial court says that a decision taken in the meeting shall not be given effect to, and a committee which has been formed on 3rd of April 2024, that committee shall not discharge its functions but till a limited date, till when? Till the appearance of the opposite party. Now, if that be the case, my lord, that is an order which, my lord, affects the entire members of the association. So this is not an order which only affects the petition. So therefore, my lord, this is an order which affects as the right in rem, my lord. My lord, your lordship, then right in rem and right in persona. Now here is a case which order you can be said that it is an order which affects the persons of all the members which are members of the society. This order doesn't personally affect only this petition. Even for the sake of argument, let us assume, my lord, that yes, the meeting was held on 3rd of April, a committee was formed. Now, if the committee was formed, that committee, their argument is that this Mr. Rabha, he is trying to grab the association. He is trying to run the association. Now, let us go by their argument, my lord. This meeting was held on 3rd of April. After the meeting, a committee was formed. Now, if that be the case, that committee ought to have challenged the order that, see, in that meeting, a lawful meeting was held, and by virtue of that meeting, this committee was formed. So, therefore, we are aggrieved. So, we have challenged this order. None of the committee members are before this court, my lord. So none of the committee. So therefore, at the outset, I would say this petitioner doesn't have any locus to file this petition or the appeal before the lower appellate court, because it is not an action in personam, it is an action in rem, and the society has not come, the entire elected society, that has not come. The personal right of this petitioner is not affected, so therefore he cannot maintain this petition. Had his personal right been affected, my lord, he could have assailed or approached your lordship, that would have been a different. His personal right is not affected. It is an order which has affected the right of a committee, of a association. So the association should come and say that this order is wrong. And though today it has been argued before your lordship that the question of maintainability was raised before the trial court, my lord, I was the counsel before the trial court, and this petitioner was the caveator. Caveator was heard. With all respect, I would say, my lord, this question of maintainability was never raised before the trial court. The issue of maintainability was never raised before the trial court. It was raised for the first time before the appellate court. And my lord, the caveator, this petitioner as a caveator was heard and order was dictated in the open court, not that after 2-3 days. The trial court had dictated the order in open court. The caveator was heard at length. So therefore, my lord, it says that the caveator has heard at length. Now, if the caveator doesn't raise any point before the trial court and subsequently come and say, no, I have raised this point, my point has not been raised. So if that be the case, my lord, the order is up to, my lord, 6th of May. Today is 3rd. That appellate court had preponed it today. They could have very well gone before that appellate trial court and said that the appellate court had preponed it and you hear the matter. Now appellate court judgment, what it says, just last page your lordship will see, page 178. Page 178. However, having regard to the urgency shown by the appellant side, learned trial court is directed to take up the matter of hearing in respect of so-and-so pending before it on 3/5 today. On today, both the parties shall appear before the learned court on 3/5. Now, instead of appearing before the trial court today, they have appeared today. The matter is fixed on 6th. They could have very well filed their objection, and whatever they have, my lord, they could have hesitated before the learned appellate court, because that order, my lord, it is only an ad interim temporary injunction. It is not a permanent injunction. If it is an ad interim temporary injunction, and that is only up to a limited period, appellate court has discussed, my lord, everything, that it is only up to a limited period, that appearance of the opposite party. So why don't they go and appear before the trial court, and whatever they have say before the trial court, why they are shying away from doing this? And my lord, I have instructions to say that even we are agreeable for a court monitored election. If this honorable court says that yes, the election which will be held on 9/6/2024, on 9th of June, and we have completed the process of, my lord, this nominations of president also, that has been completed. So if we are not averse to that, even court monitored election on 9th of June, we are agreeable. So that learned appellate court, after taking all those things into consideration and keeping in mind their urgency, have preponed it and fixed it today. But instead of going over there, now the purpose is that if they can drag this matter, my lord, somehow, then 9/6 will be gone. If 9/6 is passed, my lord, they will succeed. And in the meantime, if they can file an application and get this writ appeal withdrawn, the purpose will be served, my lord. So therefore, the purpose of this meeting was not at all bona fide. It was done with some mala fide intention, and your lordship is exercising your jurisdiction under 227. Now your lordship knows very well, and by now the law has also been crystallized, that while exercising jurisdiction under 227, your lordship has to see only what is the jurisdictional error. Now, granting of injunction is a, my lord, discretionary order. The trial court, upon being satisfied, had passed an order. Rightly or wrongly, it may be, but the trial court has passed an order. The trial court has exercised its discretion. Now, being aggrieved by that, Even after hearing the caveator, who is the petitioner before your lordship, now the respondent petitioner, he prefers an appeal, and even the appellate court says that, see, as there is urgency, matter is preponed, and the law is well settled that the appellate court will not substitute its finding with the finding of the trial court. So therefore, the appellate court rightly refused to interfere, but it preponed it and fixed it. Now against that they have come. Now where is the, my lord, jurisdictional error? Today they are saying that maintainability and all those things. Why don't you raise those issues before the trial court? You file your pleadings, raise those issues before the trial court. So therefore, lordship has to, my lord, examine this case in a very narrow campus of jurisdictional error. Now my respectful submission is that, my lord, there has been no jurisdictional error. So as there is no jurisdictional error, and moreover, as this petitioner has no locus to file this case, so therefore, my lord, it is not at all a fit case for interfering, as is liable to be dismissed in limit. Now, regarding this jurisdictional matter, my lord, I would like to refer upon some judgments, my lord. AIR 88 Supreme Court 184. My lord, para 13. My lord, I have underlined, my lord. Regarding, my lord, it says about jurisdiction of 227, my lord, where two views are possible and the trial court had taken the view which is possible and plausible view merely because another view is attractive, the High Court should not interfere and would be in error in interfering with the finding of the trial court or interfering under Article 227 of the Constitution over such decision. Then, my lord, will refer to, my lord, 2001 AIR 2001 Supreme Court 3295. Para 6 and 7. In para 6, my lord, this underlined portion, it is also well settled. What you got it, page 5. Para 6, it is also well settled. It is also well settled that the High Court, while acting under this article, cannot exercise its power as an appellate court or substitute its own judgment in place of that of the subordinate court to correct an error which is not apparent on the face of the record. The High Court can set aside or ignore the finding of fact or inferior court or tribunal if there is no evidence at all as to justify or findings is so perverse that no reasonable person can possibly come to such a conclusion which the court or tribunal has to come. Then para 7, my lord, I will read it from middle. This court in so and so has observed that the power of superintendent under Article 227 cannot be invoked to correct an error of fact which only a superior court can do so in exercise of its statutory power as a court of appeal, and the High Court in exercise of its jurisdiction under Article 227 cannot convert itself into a court of appeal when the legislature has not conferred the right of appeal. Thus, by this pronouncement, the High Court has clearly exceeded its jurisdiction under Article 227 in passing the impugn order. But even if your lordship finds that, yes, this jurisdictional error, non-maintainability, nothing, my lord, these are matters of evidence. Now they say that there was no authorization of this president in charge to act as the president. Now we say, my lord, yes, from the documents itself, my lord, we have been able to show that he has been acting as president in charge from 2021, and you were also party to that. Now in that event, my lord, these are disputed question of facts. How these facts will be ascertained, my lord? These will be ascertained by way of evidence. So therefore, my lord, without going into evidence, on the face of it, you cannot say that whether this is right or wrong, because the evidence has to be there. Had it been an appellate court, my lord, your lordship could have gone into the depth of that thing and could have decided. But here, your lordship only has to say whether there is any jurisdictional error or not. Then, my lord, 2009-17 SCC 429. 2009-17 SCC 429. This also relates to injunction, my lord, that whether there was a path or not, it relates to something. Now, how this case arose, para 2, my lord. The appellant before us is the original plaintiff in a suit which has been filed for declaration and injunction, as noted here earlier, against the order of the High Court, setting aside the concurrent orders of the courts below, allowing an application for injunction pending disposal in a suit. This appeal has come. Now, here is a case, my lord. Two concurrent courts have decided in favor of the plaintiff, but the High Court had reversed it. Now, taking those view, what the Honorable Apex Court has said, my lord, next page. In our view, the finding arrived by the courts below cannot be said to be perverse or arbitrary, for which the High Court could set aside the said orders in exercise of powers under Article 227 of the Constitution. On a thorough reading of the judgment of the High Court, which is under challenge before this court, and also the orders of the court below, it can be said that there is some arguable point to be gone into for the purpose of deciding whether the appellant plaintiff is entitled to an order of injunction restraining the respondent from interfering in the access of the said premises of so-and-so site by the appellant and its customers, in addition to the gate on the other side of its hypermarket. Since this is a question to be gone into on evidence at the time of trial, and in view of the fact that the appellant plaintiff and their customers were using the said entry from so-and-so lane to so-and-so, we are of the view that at this stage the High Court was not justified in exercising its power under Article 227 of the Constitution to set aside the concurrent order of the courts below, which by means cannot be said to be perverse or arbitrary. Then the findings of fact recorded by High Court courts below are supportable on evidences on record. So even that is why they say that there was no authorization. Now, in evidence, if it comes out that there was a authorization, and in there, suppose my lord, take what they submit, that there was no authorization, nothing. Now, taking that as preliminary issue, my suit is dismissed. Suppose. Now, suppose the suit continues, and in evidence, I succeed in substantiating that there was an authorization wherein this Mr. Rava was authorized to accept the president. In that case, my lord, what will happen? So those things have to be kept in mind. Then there is a judgment of our High Court also, my lord, this 2004 CGLT 696. This also says, my lord, regarding exercise of jurisdiction under 227. Last line, my lord, in this paragraph, but the power of superintendent, but the power of superintendence of this court under the aforesaid article is extraordinary in nature and must be exercised most sparingly and only in appropriate cases, and could not be invoked to correct an error of fact or law. Only a superior court can do so in appeal. The High Court also would not, in the guise of exercising such jurisdiction, convert itself into a court of appeal, and its function would be limited to ensuring that the subordinate court or tribunal functioned within the limits of authority. In Surya Devi Rai and so-and-so, the Apex Court had held that be it a writ of certiorari or the exercise of supervisory jurisdiction, none is available to correct mere errors of fact or law unless the following requirements are satisfied. The error is manifest and apparent on the face of the proceeding, such as when it is based on clear ignorance and utter disregard of the provisions of law, and grave injustice or gross failure of justice is occasioned thereby. Now, in this case, what gross failure of justice will be held? Suppose, let us say that, my lord, jurisdictional error, my lord, court has said that till a particular time an order is passed, other side will appear, they will file their objection, hearing will be done, and if they can satisfy the court that yes, it is not a case for granting an injunction, the injunction will not be granted, my lord. It is not that once an ad interim injunction is granted, it will continue for perpetuity. It is always subject to argument and change. They can file objection and say. Now, second is the failure of justice. What would be the failure of justice? Now, meeting is going to be held on 9th of June. Let them participate, all the members should participate. Let the election be held in a democratic manner as provided in the Constitution and not in a hush-hush manner. You participate. If you can succeed, you succeed. We have nothing to say. So, but otherwise, on the other hand, if we are restrained, my lord, suppose the order, we just this injunction order is, my lord, vacated. Now, if the injunction order is vacated, then, my lord, whatever resolutions has been taken, I have already drawn your lordship's attention. They will succeed in doing it, and if they succeed in doing it, it would amount to perpetuating an illegality with which this meeting was held. So, will a court be a party to an illegality? With all respect, no. Then, my lord, this 2010, AIR 2010 Supreme Court 2367. In this para 6, my lord. In this case, my lord, the apex court has said that while deciding an injunction, my lord, no mini trial has to be conducted. It is not that, my lord, when the suit is filed, at the threshold, my lord, court will frame issues of maintainability, and in order to frame issues of maintainability, there has to be pleadings, my lord. Whether they have filed their written statement, whether they have filed their objection, in absence of any pleadings or objection in the injunction application, how the court will frame and pleadings, my lord. Now, pleadings are framed, my lord, there are assertion and denial. Now they will take a preliminary objection that regarding maintainability. Only then the court, and trial court, will be able to frame an issue. Now coming and submitting before your lordship that the trial court have not taken that issue, my lord, that issue, the trial court has to be given an opportunity to frame that issue, and that stage has not yet arrived. When they will appear, they will file their pleadings, their objections, preliminary ground will be taken. Then only, my lord, that stage will arrive. This is a premature argument, my lord. Now, my lord, there is other judgment of our High Court that when an injunction is to be granted. Now, this is the last one, my lord. I will not trouble you. Lordship with all the AIR 82 Guwahati 69. Para 12. Para 12. The circumstances under which temporary injunction may be granted have by now been more or less crystallized. Where in a suit it is proved by affidavit or otherwise that any property in dispute is in danger of being wasted, damaged, or alienated by any party to the suit, or to restrain the defendant for committing injury of any kind relating to the same property right, the court may grant temporary injunction at its discretion on such terms and as to such duration of the injunction, and subject to conditions as the court thinks fit. Where the defendant has this is important, my lord, I will be relying on these lines. Where the defendant has committed or is threatening what the plaintiff alleges to be a trespass or a wrong, the plaintiff may ask the court to direct the subject matter of the dispute to be maintained in status quo till the issues between the parties has been determined. Where the sole object of a suit is protection by means of an injunction, to withhold the temporary injunction may practically decide the cause in favor of the defendant without giving the plaintiff an opportunity to establish the truth of the case made out by his plaintiff. And in the middle, the court should grant temporary injunction if the effect of non-granting an injunction will be to deprive the plaintiff forever of the right claimed by him in the suit. Now today, my lord, if your lordship, my lord, vacates that order, interim order is vacated. Now if interim order is vacated, my lord, the apprehension which we have portrayed in our claim, my lord, that will be frustrated. If that is frustrated, my lord, can the clock be again put back? With all respect, no. Because the action which they want to do, that will already be done. So therefore, my lord, the learned trial court, in exercise of its discretion, has passed a reasoned order, and the appellate court also, my lord, has not interfered with that order, because all the requirements of granting an injunction has been discussed in full, and the court has given an opportunity. It is not that this order was passed without hearing them; it was passed without after hearing them, and so therefore there is no perversity in the order. And if this order is so illegal, my lord, why the other members are not coming? I fail to understand what interest this gentleman have in this litigation. Why he is so much interested in his personal capacity to pursue with this litigation. The subject matter of the suit has nothing to do with some personal property, my lord. Therefore, my respectful submission is that, my lord, this is a fit case for dismissal. Let them go. Matter is fixed. Today is fixed, my lord. I don't know whether they have gone or not. It is fixed on 6th. Let them go on 6th. Let them hesitate whatever they have to say before the trial court. Let the trial court decide. Suppose, my lord, trial court, after hearing them, whatever they are submitting today, their trial court finds that yes, this order is not liable to be extended. My lord, it will not be extended. What is there? Why they are shying away from going before the trial court? So that is my response, sir.
Lord, I'll be brief, my lord. Just a few. I'll just place 5 points, but before that, if I may address 3 particular submissions that have been made by my learned friend. My lord, it may be in the nature of an ad interim order, my lord, but your lordship will mark that it's a bi-parte, inter-parte order. Because I was present on that day, and though the court records that the caveator has been heard at length, none of the submissions were recorded. So insofar as I am concerned, it's an inter-party, it's in the nature of an inter-parte order rather than a usual ad interim order. So since the caveator was heard and he has already expressed, the learned trial court has already expressed his view, it is clear that insofar as my objections are concerned, that matter has already been decided. So therefore, once if I go back to the trial court and I urge these points, he would perhaps be in the nature of a functus officio, so as to take a different view from what he took on the first day, which is why we have come in appeal and also in revision. That is number one. So your lordship will mark the nature of the order. It is not a usual ad interim order, but an order passed after hearing the caveator. So I have virtually exhausted my defense there, which is why I'm here. Number two, my lord, I find that a submission has been made that I have no locus to institute this particular revision. My lord, I fail to understand that distinction between a judgment in rem and personam. I will not go into that. But your lordship will mark that I am arrayed in my personal capacity as defendant number 5. So despite being made defendant number 5 and you having obtained an order, can I not challenge it, my lord? Additionally, in the new committee, I am the general secretary. So to say that all the 450 members or the 31 elected members have to come together to prefer an appeal, otherwise the appeal will not be maintainable, in my respectful understanding is a little absurd. Now, the third argument that I'd like to address is regarding the involvement of a particular gentleman called who happens to be the chief engineer PWD. Now, if your lordship goes through the plane, your lordship will not find a single whisper. This is not born out of pleadings. This entire argument is to digress from the real issue as to whether election should be held for the association or not. Now, intriguingly, that particular gentleman, which my learned friend has addressed, the judgments have also been placed, is not even a party to these proceedings. Now, to welcome those allegations of fact regarding him being involved in some embroiling litigation, this is dehors the pleading, and in my understanding, it cannot be agitated here. Now, coming to the issues at hand, my lord, my friend has used the pronoun we. Now, I would say there is no we here. It is just one person who poses as the president, and it is versus 450 members who have formed an association. So therefore, it is a contest between 450 odd members and a single person who calls himself the president without a nomination. Now, therefore, I would say, my lord, all the flaws in the election process can be looked into by the court, provided he satisfies that he has locus standi to maintain the suit. Because your lordship will mark, he has approached the court, and therefore it is for him to satisfy that he is the president. Now, he could have sued in the capacity of a member also, and the suit would have been maintainable. But given the description of parties, he's not suing in his personal capacity or as a member, but is suing in the name of the association itself. Now, can he do that in view of Section 6? That is the first question which the respondent plaintiff has to address so as to satisfy that the suit is maintainable and an injunction is tenable. Now, injunction, we all know, is an equitable relief, my lord, and therefore the conduct of the plaintiff is very important. And here is a case, my lord, where he says, if I've understood the argument correctly, he says that as per the constitution, it is the president who has to be at the helm of affairs, and as the outgoing committee, he has to call for elections, and he having not done that, this particular election is bad in law. Now, so his basic argument is, I am all in all, I am the president, and he says only I can call for an election, but he himself doesn't call for an election for 8 years. So what do the members do? So which is why they had to resort to an extraordinary general meeting. On one hand, he says only I can do it, and on the other hand, he doesn't even do it for 8 long years, which is why the members stepped in. Now, the basic thrust of the argument is we are in 227, and therefore, if since it's a matter of discretion, and therefore the appellate court, or for that matter, this court should not interfere, my lord. Now, we would say, my lord, there is a jurisdictional error, and there are three pertinent reasons why this court should interfere with the orders passed. Number one is perversity. Now, that is an exception to the general rule that in matters of injunction, the appellate court will not interfere. Now, what is the perversity on record, my lord? The perversity on record is 11.1 was not even considered, which is the basic edifice of their locus standi to sue. They say I'm the vice president, but I was elected as the vice president, but I have become the president, and therefore I can maintain a suit on behalf of the society. Now, to decide that particular question, clause 10.1 is the most vital, 11.1 is the most vital clause, and that particular clause has been ignored. So, if the main clause of the constitution is ignored, is it not perversity? And if it is perverse, then no matter injunction being a discretionary relief, the appellate court, or for that matter, even the high court would interfere. 11.1 and also 12.2 or 2b and d, which says the general secretary, or in his absence the joint secretary, should call for it. So it's a misconstruction of the constitution. It's the ignorance of the relevant clauses, which is why it is perverse. Number two, 2024 judgment is very clear. If I have understood it correctly, it says the moment the question of maintainability arises, the court will first offer a finding whether it is maintainable or not, and then go on to grant an interim relief. That exercise preceding the grant of an interim relief has not been done by the trial court. Now, a submission has been made that the issue of maintainability was not even raised before the trial court. Now we are only left guessing because of the order itself. The order says caveator has been heard at length, but we don't know from the order. Their submissions have been recorded, the caveator submissions were not recorded. So today we'll have to go by the word of my learned friend who says that issue was actually not raised. But we don't know for certain, we don't know for sure, because the order itself does not reflect what were his precise submissions. Secondly, my lord, this particular issue of maintainability at least was raised before the appellate court, my lord. Now, the appellate court also, for some reason, does not visit this particular vital aspect of the matter as to whether the suit is maintainable or not, which is why we are saying that the matter should eventually go back, but the order should be set aside and the trial court should be directed to decide the question of maintainability before even going into the tenability of the injunction, prayer for injunction. And lastly, my lord, why this court should interfere is because the trial court and the first appellate court ignored the settled position of law regarding grant of injunction in these society matters. Now, for that, if I may just quickly place three judgments, my lord. First is the judgment of the Supreme Court Bar Association versus V.D. Kaushik, my lord. My learned senior had already pointed out that the prayer for injunction is identical to the prayer made in the main suit. So virtually the final relief has been given at an interim or rather an ad interim stage. Now, first, if your lordship takes up para 39 of that judgment, your lordship.
Yes.
This court, in a catena of reported decisions, has laid down the principle that interim relief, which has tendency to allow the final relief claimed in the proceeding, should not be granted lightly. No special circumstances have been mentioned in the impugned orders which would justify declaring the suit at interim stage. The relief granted by the learned judge at the interim stage was not warranted by the facts of the case at all. Therefore, the impugned orders are liable to be set aside. Now, the prayer at page 81 has been granted by the court at an ad interim stage. Now, going further, my lord, para 43, if your lordship takes up. Just one line from the paragraph, my lord. It hardly needs to be emphasized that in any body governed by democratic principles, no member has a right to claim an injunction so as to stall the formation of the governing body of an association. Now, para 52 thereafter, my lord. In matters of internal management of an association, the courts normally do not interfere, leaving it open to the association and its members to frame particular bylaw, rule, regulation, which may provide for eligibility or qualification of members and or as a member of the association. So when it comes to internal management of an association, it's a settled law. The court should normally not interfere, my lord. Now, if your lordship takes up the Madras High Court judgment, my lord, that is M. Sekar versus Tamil Nadu State Council of Communist Party of India and others. This is also concerning a society, my lord. Page 6, paragraph 15, if your lordship takes up. Paragraph 15, my lord. From the rival contention of the parties, it is evident that the challenge made by the applicants as against the election of the second defendant as state secretary is to be considered and decided only after conducting a trial by allowing the respective parties to adduce evidence in support of their respective pleadings. Therefore, when it is evident that the challenge made against the election of the second defendant is to be considered and decided only in the main suit, the question of preventing the second defendant from functioning as a state secretary in the meantime by passing an interim order does not arise. More particularly when facts are in dispute with regard to the procedure to be followed in electing such person to the office. Moreover, in an election dispute, unless the election itself is set aside, preventing the party who got elected from functioning in the elected post does not arise. Therefore, I find that the plaintiffs have not made out a prima facie case for grant of an interim injunction. So, this is the law concerning election in all election matters, that there could be disputed facts. Now, the respondent alleges that the procedure was not followed. I say that the procedure has been duly followed, etc. Now, these are questions of fact and which will be decided at the time of trial. Now, the question is, before that decision is arrived at, will the court pass an order of injunction? And the courts have consistently held that in election disputes, you set aside by election, then you get the relief. But at that intergenum period or in the interim, You're not entitled to an injunction restraining me from discharging the affairs, discharging my duties. Now, last, the Delhi High Court judgment, my lord. This is Delhi Cloth and General Mills versus Dharam Singh. Para 2, my lord, on the first page itself. Interference in the democratic process of elections, particularly at interim stages, should be sparing. The democratic process should not be stopped in between because the final result can always be challenged. So they challenge the final result saying that the elections are bad. Now that will be decided in the trial, but the courts have consistently held, now do not injunct. There should not be any injunction to the effect that restrains the parties elected from discharging their duties. So this particular settled law was ignored, my lord. There's perversity on record. The issue of maintainability was not even gone into. And I would also say the caveator being present, at least he should have been heard, because this order is in the form of a bi-party order. So therefore, I've already laid my defense there, and it is perhaps not likely that a different view would again be taken, because the court has already made up its mind, which is why we are under 2 to 7 minutes.
My lord, I'll hurriedly just distinguish the judgments referred to by my lord. Lord, first of all, that regarding presence of 450 members, perhaps I have not been able to convey my submission. My lord, my argument was not that 450 members should personally be present and challenge. My argument was that, my lord, when their contention is that in an extraordinary general meeting, an executive body has been formed. Now, if that body has been formed, they say that it was formed in accordance with law. If that be the case, now who is aggrieved? The body which is formed that has been restrained from discharging its duties. So the body should come before the court and challenge it. And they knew very well. That is why, while lodging the caveat, my lord, this lordship will kindly see this caveat which was lodged before the trial court. Because it is not that they are not aware about it. Your lordship will see this caveat. Who has lodged this caveat? This caveat was lodged by the petitioner in this capacity, not in his personal capacity matter. The caveat was lodged in his representative capacity as general secretary of this so and so, because they say that meeting held, I am the general secretary, I have filed a caveat. If you have to say anything, you say. Now, once you have filed a caveat, you know your stand very well. Now, the association represented by the petitioner ought to have challenged the order. That was my argument. And on the other way, my lord, even if this petitioner says that yes, I have the authority to challenge, then my lord, the provisions of Order 1, Rule 8 will come, suit in a representative capacity. And in that case, my lord, the provisions laid down in Order 1, Rule 10, Rule 8 has to be followed in what manner. So that is one. So my argument is that association should assail, not this gentleman as petitioner. And regarding that Supreme Court Bar Association, and in that judgment, my lord, the Supreme Court has said that the petitioner, in that case, the petitioner had challenged that this election is illegal and some rules were to be framed and noted. Now, those are cases where a single individual, unsuccessful candidate or a contesting candidate, they have challenged the election. But here is a case, the unsuccessful candidate or a contesting candidate is not before the court. Who is before the court? The association itself is before the court. So that is the distinction. The court, in those judgments, the court says that by democratic process should not be scuttled. My lord, we are also saying that same thing. Democratic process should not be curtailed or scuttled. So that is why participate in the election, let the election be held in a democratic and free and fair manner. So those judgments, my lord, the individuals who are affected, they have preferred an appeal. And in that context, my lord, these orders were passed.
My lord, how does the association sue, my lord? Association is not made a party, my lord. They have usurped and become the president.
Even my lord, in injunction order 39, your lordship has vast experience. Your lordship knows order 39, other persons are also there. They can also come.
Exactly. That's
yes,
why we are here.
That is why you have filed your caveat. You have filed your caveat. You know what is your position. But you choose not to exercise that position. So that is my respectful submission.
Uh, Space, but the argument was too
Too
long.
lengthy.
So, as the order, it be complete today, if not. Let us see, try. If not possible, then Monday.
I'm deeply obliged.
But is contemplating to dispose of, otherwise we had an interim prayer, which is
My
not
lord, I am
disposed.
objective to it, my lord. If interim prayer is, my lord, granted, my lord, my entire suit becomes infructuous.
So your lordship
That,
decide.
my lord, entire suit become infructuous.
Better to don't have to uh, some other matters. It's already one, two. Add two then. Uh, do not find any illegality committed by the court below while disposing the petition, and accordingly, as a result, the present petition stands. Complaint case number 044 2021 is hereby referred to file with the direction to the petitioner to appear before the learned trial court below on or before 8:05. It is restored.
Highly obliged.
The revision petition stands dismissed. In fact, this was a jail appeal. So, but I found that at the time of, framing of charge, he pleaded guilty. It's a case of the foreign national. In fact, so accordingly, conviction order was passed. So I didn't find any irregularity in convicting the appeal. However, by that time, most probably conviction period is already over. So we made a direction to, uh, I mean, uh, to do the needful in releasing her, and apart from that, deportation order will be there also. They will do the needful in regarding the deportation of the date. Criminal petition 412/2023. And but one but one that
It is a lordship. As Becky mentioned, also item number 55. I will not be able to do 55. It may come on any day next day, except for today. I have taken a concern to other side of Ovilas. 55. Maybe next week or problem.
May it please your lordship, I pray for adjournment in the case. Item 4. My lord. My lord. My lord, we are yet to collect instruction from the insurance company. Therefore, after 2 weeks it may come.
Obliged.
2 weeks, madam. Obliged.
May it please your lordship. Lordship, this statutory appeal against the judgment and decree dated 22/2024 passed by the civil judge. Lordship will find the judgment at 152, whereas all the issues framed were in the affirmative in my favor. However, the learned court did not allow the first prayer which was made. That was for execution of the sale deed. It is a matter relating to sale of a plot of land. So that was not allowed. Lordship, I am against that. Lordship. At this moment, Lordship may issue notice and the judgment may be stayed for the time. The issues framed, Lordship will find at page 161. There was an agreement between the appellant and the defendant number 1. And in terms of the agreement, Lordship, the appellant had already paid an amount of rupees 11 lakhs. And even after that, all the issues having been answered in my favor, this prayer for execution of sale deed has not been made.
In that, is there an issue? Issue number? No, regarding your prayer for execution of this sale deed.
That is my
That is a page. The issue includes mostly to
lordship
8.
at page
So issue number
162.
8. That
Any
is,
lordship, see issue number 5, issue number 4, 5, and 8.
otherwise, all those issues were discussed in.
In my
It's
favor.
decided in your favor.
In all the issues were decided in my favor.
Pardon, sir. Okay, to call you're a personal bank only. You're here.
Yes. This is a private case, lordship.
Hard Mr. Hardy. Done it. That's an appeal against judgment and order dated 2024, 22/0/2024. As by Done Judge number 1, M. Guwahati, in statute number 219/2022. Submitted by Mr. that in the said case or issues were decided, however, the prayer for execution of said uh, and for which present has required the order of or judgment and order the next considering the submission made by affidavit that it do not respond and state the execution of operation of judgment and decree dated 22/02/2024 till this but issue notice. I have also called for DLC.
Yes.
After 4, list up.
May it please the Lordship. Lordship, in this case, what happened is that the claimant filed the case but did not make the owner of the vehicle a party. Why? Because the owner had died. So the legal representative of the owner should have been brought on record. They did not do it. So that is my first point. Because of that, the claim petition itself was not maintainable because only the insurance company was made a party. Then the insurance company adduced evidence and the court came to a clear finding that there was violation of policy condition. And then, Lordship, the court directed that this person, the insurance company will recover that amount from that dead person, Lordship. So, it's a genuine ground, statutory appeal, but I mean, I do not know why the judge did that. So, Lordship may admit the appeal.
So you are appealing for?
Yes, ma'am. I am product respondent claimant.
Respondent.
1 to 4.
My lord, I have my submission, my lord. In my lord, High Court of Jammu Kashmir,
No,
which
we'll
was
we hear in detail all this.
Hello?
We'll hear in detail, but let us admit the appeal first.
Yes.
We'll hear in detail.
a payment may be given, my lord, because payment to the claimant may be given.
No, Lordship, how can it be? Admission, Lordship, I do not know why all the advocates in the admission part, they come and say keep payment may be given. There is a sense, make the submission there. Admission, Lordship, is for admitting the case, Lordship. That cannot be any precondition. As per the MV Act also, only thing is we have to deposit 25,000 or 50%, whichever is less.
All are claimants.
Yes, because they did not make any other party a party, Lordship. Only insurance company were the opposite party. So that itself is
one. Then against the judgment appeal under section 150 MPA against the judgment and award dated 2005 passed by learned member MSCP 3
Yes, Lord.
number Kamrup M. Guwahati in MSC with number 689 of the subject. So the Turkey Muzumdar that the uh, the advocate, the owner and driver of the vehicle died during pendency of the
No, not pendency. Before. Beforehand, they did
died
not.
before the update, before the claim
At the time of accident, he died, my lord. The owner died.
was filed. However,
Same accident.
no, the
Mm. He died before filing the petition. No, I don't know.
Before
filing the petition.
It really cares about it.
Did not make a legally its owner at court and directed the present appellant to pay and recover the award considered that there was a violation of the for the appellant that however no problem but as did not both of the day
Already given, Lord.
already
Yeah.
all
And there are other grounds also, Lord. Amongst these, there are other grounds. Yes.
And what is the IA for?
I for stay, Lordship. Lordship, we need a full stay. And I think they will oppose, so they can file a objection to that, Lordship. That will be my prayer. Then Lordship will hear the whole matter.
They will
Otherwise,
not-
I have my
They
certificate.
will not object. I think if you deposit 50%.
Lordship, we
50%
cannot.
We are not going to pay. 50%.
No, we cannot. Dead person, Lordship. How can case totally was not maintained?
And it should not be
Mohit,
They will file.
I am the party.
They will file objection. They have got the.
No, my lord. That may be hearing for the fixed for the hearing, my lord. And lecture may be called for. No objection, I will file. I will argue in the hearing, my lord.
Then Lordship, stay may be granted.
In this stay, you are not going to
Regarding
check.
say, I will file any some petition, my lord. Regarding payment, I will file some petition, my lord.
No, there is
Question is that they are filing this IA for stay of the execution of the award. So in that regard, do you want to file any objection? Or if you don't want, then we have to pass the order on stay.
I will file objection.
Objection will file.
দি দিব পিটিশন দি দিব অবজেকশন দি দিব জি তেনেহলে ষ্টেটো লৈ লওঁ যদি আপুনি পিটিশন বেলেগে দিয়ে ঠিক আছে তেনেকে আপুনি কয়
So you are going to file the objection? You file it. And if the LCR comes, matter may be heard finally also.
yes lordship even we want it highly obliged
May it please, my lord. My lord, this appeal has been filed for enhancement of compensation. The grounds of appeal are, my lord, the learned tribunal has erroneously taken multiplier from the age of your parents. But the deceased was an unmarried person, so the multiplier should be taken from the age of the deceased. Here the multiplier is taken 11. The appropriate multiplier will be 18. And second ground is, my lord, the income is taken very less, 3,500. It should be, as per notional income, it should be at least 8,000. And no future prospect was awarded.
Hard MS, hard return of body. It's the net. It's the net. What against judgment award case number 95 of 2009 by judgment and award dated 2007 submitted by MS Hard that basically represent applied for challenge for enhancement of the award caused by the never applied that should not also for
Much obliged.
My pleasure, Lordship. Lordship, this appeal has been filed on the ground, Lordship, that appellant insurance company was not given an opportunity to adduce evidence. What had happened, Lordship? There are three
insurance company was not given any chance for reducing
chance. Lordship, what had happened in this case? It's not like that also. There are four analogous cases. So insurance company had filed three petitions, said to save the court, time of the court, all the four should be tagged so that one common date for evidence may be given, the defense evidence. But three petitions, there no order was passed on three petitions, and the judgment was delivered. That was the only reason. Now, my lordship, I have inquired. The other cases are in the argument stage. So, all the purpose of filing this was there should be one common finding of errors and negligence. If judgment is passed without giving us an evidence, maybe I don't know what will happen in the other cases. That was the reason. But if these cases are decided in course of time, in a short time, they are already in argument. I'll file after this matter is admitted, I'll file a petition for application for adducing additional evidence in appeal. So at the moment, lots of this appeal may be admitted. I think part of the liability will be on me. So 50% can be recorded. Two vehicles were involved. It is under insurance company. So it's a case of maybe composite negligence.
Yes, Mr. Monfort, your name has been reflected there.
Yes.
This time
Now this time, though it was fixed on 1st of May, but even though it has come on 3rd of May.
It was अच्छा ये थे हाँ.
Lordship, so far admission of the appeal is concerned, I have no objection. It may be admitted. And in the stay application, as my learned friend has agreed that he will deposit 50%. On such deposit, it may be released.
You really think it will have any objection? So for you, other three connected cases at the stage of argument now.
In the stage of argument, one has been withdrawn. The other two are in the stage of argument.
My case has been decided on in the year 2022.
But the
other two cases are still pending.
16 February argument.
So you are representing how many respondents?
1, 2, and 3.
1, 2, and 3. 4 is one owner driver.
Owner driver.
Appearing on behalf of the number 1. This appeal has been filed against the judgment of award dated 20 March 2020, passed by Granted Member MSP 1, number Act, in MSP case number 394 on the section 1 of the issued the response number 4. Also for this recording. And 185814 her change was then already I have picked it the state for stay of 20 and 50% with and the respondent number 1. You are the claimants 120.
Yes, 120.
Will be at liberty to withdraw. That with the work of the I. Okay, it will be disposed of. We will be at liberty after
Highly obliged.
84 weeks.
May it pleases your lordship. Lordship, this appeal is filed because the policy which was in fact exhibited by the claimant themselves, which showed that the premium was paid for one labor, and this was the second labor. Already in MSC case number 54 of 19 at Gwalpara, the compensation for that labor was already given. So if there is any liability, it will be owner's liability. Owner has to pay. That is our main ground of appeal. And with other grounds, that if employee comes, then the calculation will be as per WC Act and all. But the main ground is this, Lord.
My lord, this, as per section 147(1), my lord, this case is covered by one section 147(1), my lord, because as per section 147(1), my lord, against any liability which may be incurred by him in respect of death or bodily injury to any person, including honor of the goods or his authorized representative, my lord. Or his authorized representative of goods. That's
Yeah,
our
our
case.
submission is that as per the condition, mostly one labor was.
But that the policy that is not come in my case, man.
That has come.
No, man.
No, your claimant exhibited the policy.
Exhibit that
In
policy.
that premium was paid for only one labor.
But here in this case, my lord, he is authorized representative of goods, my lord. As per section 147(1), my lord.
He was the authorized
Representative
representative
of goods, my lord. Goods, my lord.
Regarding admission, do you have any?
Admit the appeal, my lord.
So you are appearing on behalf of
1, 2, 3.
1, 2, 3. 4 is owner cum driver.
Owner cum driver. We have to, I think, take steps on on that, on him.
Also had the learned counsel appearing on behalf of people number 1. This is an appeal against under section 170 of the PMP Act against investment and award. It is 0403 passed by panel member MSC Valpada in MSC case number 50.
'54 of 19. That's mentioned in round number B. MSC case number 54 of 19.
But it is submitted by Ms. Muttar for the evidence that regarding considered premium, that considered fact premium was paid for the owner by the owner for covering the legal liability of only one labor, and also did not consider the fact that the one labor was already paid as per judgment passed in MSC case number 54 of at Gulf. Well, 1, 2, and 3. It should respond. Follow it's according.
Highly obliged.
May it please your lordship. So this is an MSc appeal, lordship. The ground is that, my lord, the claimant was an occupant of a vehicle insured under liability policy. The private car, lordship.
It was a private car.
Private car. Policy was liability only policy.
Other I are for what?
Lordship, one I is for, I number 1252 is for stay, and 1254 is the Lordship petition under order 41 rule 27, Lordship. Because I am not praying for state, Lordship, because notice may be issued, the stay may be considered on the date of appearance because policy was not produced before the court. That is.
Then appeal the second one against it judgment in court dated 29/01/2024. Last five. Learned member MSC Group D. MSC case number 78. If between the award, the judgment and award put to challenge mainly on the ground that no occupant is covered under the policy of insurance in respect of the vehicle in question, and it was insured under act or under act of liability policy. It was act of liability policy what?
Act policy or liability only policy?
It was the act policy or liability only policy. These two, I will be heard only after their appeal.
Lordship, an order may be passed on the 1252, Lordship, that stay may be will be considered.
At least we can issue notice.
Lordship.
1252 also.
Much.
Yes.
In this case, Lordship, this is was a co-employee of State of Assam, Lordship, and there is no loss of earning, Lordship, as per the COP notification, Lordship.
It was a government employee.
Lordship.
This is an appeal. Appeal under 150 PMK against the judgment and award dated 05/01/2024 passed by a member at City Kamrup R at Amilgaon in MSC case number 219 of 2019. 19. It is submitted by Mr. Bhatt that the learned court below did not, the learned member MSC did not consider the notification of the Government of Assam dated 1/4/17. Also not considered the fact that as per that scheme, the family of deceased is getting pension to 100%, equal to 100% of last withdrawn. Also call for DLCF. I is what?
I for stay, Lordship.
Still, we hear the matter at the appearance.
We can deposit 20%, Lordship.
20%.
20% of the order.
It will be hard. It will be if it will not treated. Okay, otherwise we are treated.
I beg your Lordship's indulgence. This is an MSc appeal. I'm appealing for the claimant appellant. This is for enhancement of the compensation. There has been an inadequate compensation disproportionate to the grievousness of the injuries. The grounds of
here your appeal, the respondent is our only private party or are the insurance company?
is the insurance.
Insurance is also there?
Insurance is the respondent. And the private
The
party
respondent
too.
number 3 is the insured.
Respondent number 3 is the insurance.
So basically, you are paying
for the enhancement of the compensation. It has been very inadequately given. It doesn't be in proportion with the injuries that has been suffered. Many of the effect has not been regarded. That's my humble submission before your lordship is that the claimant it needs to be enhanced. It may be admitted.
Arbiter
Argus one.
Argus not be done account for this is an appeal under section 173 of the MPA against the judgment and award dated 30/01/2024 caused by London Member City 1 Kamrup M 115 evidence number 991 of submitted that the 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 award was not the award the awarded amount was not and presented by present evidence required for paying for assessment of award. I believe that do not distribute content number that content to register it also called for this award.
Well, with a limited prayer, this appeal has been preferred, my lord. Well, appeal has been awarded in favor of the claimant, but while calculating the amount, my lord, from the my lord, salary, page 31, my lord, para 46 of the judgment. My lord, page 31. In serial number 1, my lord, total monthly salary for the month of June to June 19 after deduction of attendance charge and leave encashment, rupees given. So, my lord, as subsequently in serial number 4, it should be 4. Tax also deducted, 60,000 already tax deducted. As per the salary judgment, my lord, only net salary means deducting taxes. Other cannot be deducted. So, my lord, at this stage, it will maybe admitted, my lord.
So basically, it is enhancement.
Enhancement.
Administrative paper regarding conflict for the is an appeal on one against the judgment and award dated 01/4. Past been episode number 84 by that 3 Kampur M 1 that the compensation no compensation was not assessed properly and hence the appeal is required for our appeal should not dispute responses to register it and as of court this recording. Okay, did that.
In this case, there was delay in filing the appeal, Lordship. Notice upon the respondent was, Lordship, served through paper publication, Lordship, and accordingly, affidavit was filed, Lordship. Regarding respondent number 2, we have to take fresh step, Lordship. Neither ready nor unserved notice has returned back. Kindly see the order dated 4/12, office note dated 4/12/2023.
As per office note dated 4/12/2023, it's seen that the no answer notice or the AD card has been returned for return number. However, the notice on return number 1 is served paper publication and affidavit of service is also filed by the app. And the office issue fresh notice on the return number register date and register process. And this accordingly. Have received the no. Oh, it's a I mean for
I.
delay colony. Okay. List of 4. Okay.
May please, your lordship. Lordship, in this case, I need to take step corresponding 1 and 2. So dusty, lordship.
To dusty. Hard straight. That's for office note 34. 24. So as per the office note, you want to take steps to as usual process or what?
As usual, lordship.
Service report on behalf of
Notice issued long back, lordship, in 2021.
Service report on behalf of number 1 should as that process seat. Put stop at that context. They may be allowed to take step on number 1. Prior to okay, we are allowed to take step.
Okay. If you have
4B.
May it please, your lordship. That in this matter, my lord, we have to take steps upon respondent number 3 and 4.
3 and 4.
3 and 4, madam.
So you are 1 and 2.
Yes, your lordship.
As a whole, there are 4 respondents.
Yes.
As the you are MS?
A beyond.
Number 1. As per office note, it is 29/4/2024. It is service report. It will correspond number 3 and 4. According to the evidence, expressed 3 and 4. This according to so since 2019 no steps has been taken. So take
Oh,
steps.
yes, ma'am. Within 7 days, madam.
Oh, within 7.
Highly obliged.
Okay, in this case, I am taking 2 week time for taking step on the respondent number 2 and 3. To ascertain the correct address.
One has already served.
Yes.
One is already served.
Okay.
Take let's get number 1 and 3.
2 and 3.
Sorry, 2 and subject the where thereof drop with according it's according
May let office note dated 22/4 reflects that unserved notice from respondent number 2 received back with postal remark incomplete address, and on respondent number 3 unserved notices are received. In the continuation application also we had to serve them by substituted back. So they are from Bulandshahr, UP. They truck corner and drive.
So from there?
Bulandshahr, UP.
UP.
So may I pray for substituted service? So otherwise we have disputed
paper copy.
Paper copy. Otherwise we have disputed the entire happening of the exchange.
So that is in regards to respondent number 3.
2 and 3, both.
Both 2 and
Owner and driver. Owner and driver, my lord, lordship will see the cost item, my lord. They are from Bulandshahr, district Bulandshahr, Uttar Pradesh. My lord, I'll pray for publication in only one newspaper,
Hindi?
widely published, yes, in Uttar Pradesh. Dainik Jagran.
mainly
Dainik Jagran.
Dainik Jagran.
Jagran. Previously also we have taken steps in that.
It is widely circulated paper in UP.
Yes, ma'am. In the IA which we have filed for condonation of delay, my lord, the same mode was, my lord, adopted.
Mr. Parashar is for
I am
1.
Procedural 1.
They were ex parte in the tribunal also.
And Mr. R.K. Bhatt of Mr. K.K. Prat and what would have been for 1. Submitted by Mr. Karna. The response number 2 the notice on response number 2 answer, and accordingly he submitted that both wanted are from the resident of district Bulandshahr, we then as they are Bulandshahr, Kapur, Uttar Pradesh. Submitted the earlier application on where you have to again in which case other earlier you have filed news
My lord, in the IA civil, my lord. IA civil,
civil.
yes, my lord, 1945/2018.
It is already disposed of now.
Yes, my lord. Delay was condoned and thereafter the appeal was admitted.
Okay. Submitted it here. I application for honorary the notice that we have submitted accordingly made that cannot take the statement submitted manner by for publication, which is quite the district of Gujarat. Of the day of the number namely Vedic Jagara in by the paper district district of Gujarat.
Date of appearance?
Date of appearance will be your advisor.
Some time will require, my lord. So, 28th of June, my lord.
20.
Thereafter, we'll file the affidavit.
28th
Oblige.
No, I is already disposed of. Which one? One more I.
May it please your lordship. Lordship, we have taken steps and respondent number 3 has entered appearance. And regarding respondent 1 and 2, we'd like to take fresh steps as a last chance. Because we have taken steps earlier, but it has not been served.
That you have not taken steps, in fact.
We have taken, but it is not being served.
So you are for 3. Third MS.
A Bora.
Third MS. Body. Third. As per Office Note Statement 04/2024, the applicant has not taken a statement of number 1. Full stop, however, it is submitted by Bora that earlier he had taken statement of number 1 and according to it, and according to if we are allowed to give best number 1, prayer number 1, still taken within this record.
Apply Lordship.
Four.
My lord, in this matter, we have taken dusty service. Accordingly, we have filed our affidavit, which has been flag marked, which is down below the record, my lord. So, my lord, at page 5 is the acknowledgement. It is acknowledged by the wife of the sole respondent, Lucky Daimari, Manibala Daimari. And why she has accepted in absence of the Lucky Daimari, that we have explained in the affidavit. That, my lord, may kindly peruse the paragraphs from 2 of my affidavit. The applicant is the Food Corporation of India. That I was authorized by the Divisional Manager, District Office, Bogaigaon, FCI, to serve the notice issued by the Registry of the Honorable Guwahati High Court, Sri Lucky Daimari, respondent in the instance case through Dusty Service. That accordingly, on 21/8/2023, I proceeded to the house of Lucky Daimari along with the court notice, including the petition, being IA number 2580 of 2019. Upon reaching the house of Sri Lucky Daimari, I called for Sri Daimari. However, Srimati Manibala Daimari, wife of so-and-so, came out and said that he is out of station for some work and given his phone number being so-and-so to contact over phone. That I called Sri Daimari on his phone number provided by her wife. Sri Daimari picked up my call and upon asking, I introduced myself that I am an officer of the District Office, Bogaigaon Food Corporation of India, and told Daimari that I have come to serve the court notice issued by the Honorable Guwahati High Court. On listening about the court notice, Sri Daimari disconnected my phone. However, my constant effort to connect with him again went in vain as he did not pick up my call. On calling Sri Daimari from different numbers, when Sri Daimari recognized my voice, he again disconnected the call. Paragraph 5. That situated thus, I explained to wife of Sri Lucky Daimari that there is nothing to be afraid about and that notice pertains to an appeal regarding contractual matter filed by the FCI against Sri Daimari. Upon understanding and further deliberation, the wife Sri Lucky Daimari, life of Sri Lucky Daimari, Srimati Manibala Daimari, ready to accept the notice on behalf of Sri Lucky Daimari and has taken the responsibility that she will hand over the court papers, including the notice, to her husband when he returns after some days. Srimati Manibala Daimari willingly accepted notice on behalf of Sri Lucky Daimari by putting her signature on the acknowledgement sheet. So, my lord, the service may be completed, my lord.
This applicant the affidavit is notified on the surface of the notice to respond to respondent Lucky Daimari, and it substitutes seek that in affidavit on the screen. That's why the notice has to be received. Notice had to be delivered to wife of Lucky Daimari, Srimati Manibala, wife of Lucky Daimari, wife of Lucky Daimari, and according she put her signature in the acknowledgement. That it submitted that submitted deputy for court evidence. Considering submitted also considering the grounds bench to be active, the services seem to be services seem to be completed. This accordingly could be distinct. Let us give one week time at least. They may appear. So we are
It was served on 21/8/2023. 21/8/23, my lord. So
Oh.
I may be taken up for continuation of delay of only 113 days, my lord.
Whatever, we'll take the
Yes, my lord.
after 1 week only. It will be listed after.
So my lord may
Any
fix
one
it
week?
up on 13, my lord.
1/3?
13th of May.
Oh, just according.
Oblige, my lord.
May please your lordship. Lordship will find order dated 16/6/23, my lord. This honorable court directed the appellant to take fresh steps, my lord, on the correct and proper address, my lord.
So number 1 and 2.
Yes, my lord. But the my lord appellant could not collect the my lord correct and proper address, my lord. So lord, may kindly allow me, my lord, 2 weeks further time, my lord, so that I can take fresh steps.
But also placed before logic book.
Earlier, my lord, it was placed, my lord.
Earlier.
Yes. Sometime because earlier we took steps, my lord, that was my lord return answer.
Arsham.
My
It's in for order to the applicant was directed to take test number 1 and 2 to register AD and magistrate process. But from the report of the Rajya Court dated 59/2023, said that the services steps are not yet taken for service of notice to response number 1. According to the thereby that take immediate steps within 7 days from the 7 days to for issuing notice to the response number 1 start date and this according to of course. You this time you take steps.
My lord.
May it please your lordship. Lordship,
Actually, nothing will happen on that day. We registered people came before
Lordship.
me. Why?
Directed to list this matter in the appropriate bench. So again, this matter will be listed before lordship.
But only question is that the 1I, 41I.
Yes,
So if you think that I can be disposed of along with, then we are not. There's no other reasons to place it before any appropriate bench.
Yes, ma'am. My lord, I have no any objections, my lord. He may be allowed to take steps, my lord.
Justice Saikya was not here, I think.
Yes, yes.
Came before, let's ask that why. I thought that 1I is there for that reason.
Yes.
So, can I? Then we can hear this one interpreted care of it. MFA, this is the order.
Yes, yes.
Okay.
In the meantime, lordship, I will take the steps on response number 2.
Response number. You are for response number 1.
Oh, yes, ma'am. I am for the response number.
So, Dusty.
Esther. Your Mr. Esther.
Age Goguri.
Age Goguri.
Yes.
which reports of the constable okay, you take steps on response number 2 to that.
Obliged.
May it be pleased, Your Lordship. Lordship, as per Office Note dated 3/11/2023, notice has been issued upon respondent number 2 through District Sessions Reserve, Mumbai by post, my lord. But as per Office Note dated 23/24, service report regarding issuance of notice upon the respondent number through usual process has not been received yet, my lord. Kindly, matter may be fixed after 2 weeks, my lord.
You want to await?
Yes, Lordship.
That is when so available. Service be abated for response. This accordingly after 3 weeks. As has already been. Okay.
Obliged, Your Lordship.
I know this matter is of condolation of delay, the delay being 340 days. May you grant us with some adequate time to reconstruct the file, as this matter has come up after 3 long years. In the meantime, you can issue notice.
For reconstruction of file and all, you can do one thing. Why? Is there any new development
No,
by that time?
we have lost the track of the file, and it has come after, as instructed by my senior, it has come after 3 years. In the meantime, may you be pleased to issue notice to the others.
But the RFA which is filed by you earlier, though it is not numbered, but the record is with us. This RFA. So now this has not yet been numbered, as because delay is not yet done. So do one thing regarding the construction of prayer and prayer for so and so will come later on. Let the matter be numbered and registered. By the time, if you find that it may be within this period, within 4 weeks or 5 weeks, you will get sufficient time to reconstruct your file. In that case, it will not be any burden for you. By that, otherwise also we have the file, so you can take some help from this file or so it is not yet numbered. So I am not going to pass any prayer for reconstruction of the file
And for
at
the
present.
issue of notice?
Now, notice you have to issue in IA. Immediately takes care because it is a matter of 2021. It is already 3 years back. So, take steps immediately on issuing notice for respondent number. How many respondents are there? 1. Oh no. Only 1 respondent. Full respondent is there, no? It's an application for your you are MS?
N. Ahmed.
M. Ahmed?
N. Ahmed.
N. Ahmed. Our name is N. Ahmed. Not for the application. This is an how many days you have said? 3?
340. After deducting the statutory period. Otherwise, it is 440.
Oh, see, it is only, you have written it at 30.
Something is wrong with
days 4, 4, 5, reckoned from the date of birth. It's not bit complicated. You have written
some mistake is there. As I have seen the office file, I saw 30, but I got some soft copies. There it was at 340 after deducting the statutory period.
These are all here. In fact, it's a 445 days, and then you have after your calculation, it may come to 300 something, but you have written as a 30. So what is the delay? We are not able to understand. Or if you want to take steps, then definitely. But like, hardware, no. Okay, you just take steps on issuing notice. Therefore, you see the file. There are some defect that it will be difficult for you also. So at present, I'm passing the order of take steps only, and you go by the record and see what is the for how it is.
May it please your lordship. May it please your lordship. As per order dated 26/5/2023, the legal heir of the respondent number 2 is substituted.
Legal is for respondent number 3.
Two is substituted.
As per?
As per order dated 26/5/2023. In IA number. In IA number.
Order dated 26/5.
26/5 in IA number 846.
848.
846 and 835. 846. There was an IA which was disposed on. IA for the substitution of legal representative of respondent number 2.
You don't have any order on 846.
846.
No order. One order is there in item number I4848.
848.
But 848 is not substitution, it is for therefore setting aside
Setting
the
aside. Setting aside.
Setting aside the
Setting aside. Lordship, but in another, there is another item number 28. There is another case, that is MAC appeal number 308. In that I 835, I number 835. That is also for substitution of legal heir of respondent number 2. The same respondent in both cases. Two died. And as per order dated 26/3/26/5.
Order dated it was allowed. Whether it have implemented?
Allowed. Implemented.
Not implemented.
It was directed by the honorable court to substitute the directed to the registry to impede the respondent number or legal heir of the respondent number 2. So we are allowed to take the steps for legal heir of the respondent number 2.
All right. So in the main cost title of the memo of appeal of MSc appeal number 23, it has to be amended, no?
Amended.
Oh, it.
Now we are allowed to take steps for the to the legal heir of the respondent number 2.
It's already allowed to take steps.
No, it may be allowed. It may be allowed to take. We are not taking the step.
by order dated 9/11/2020 to effect, were allowed to file in subsequent petition.
Yes, look, we have already filed, and accordingly, the
Order. So you are appealing for whom?
Respondent number 1.
1. And what about 3? For 3. You are Mr.
SRA Nasir.
N.
RA Nasir.
ABI.
Yes.
You are Mr. It was submitted by Mr. Submitted by Mr. It is one of our type according to prayer for substitution of the allowed in I civil number H35 in person state order the name of the carriers of respond number uh, included as respondent number point 1 and point 2. Stop. Okay. The capabilities take phone number 2.1 and 2.3 record. Same order in item number. In item number 28, there are other IAs. I think I list item number 28 or the item number 28. In item number 28 also there are 3 IAs.
Same. One is for stay of the order, one is for delay condonation, and one is for substitution of legal heir of respondent number 2.
Delay was already condoned.
Delay was condoned. In item number 28, there is a IA 835 for substitution of legal representative. IA number 335. 835. Sorry. 835.
MSc appeal number 328. And I 328. Same order, the order I passed. Just mention appeal number 41. Basically same. And it is IA 835 for more than one. One order per pass. So was there only one common order?
We have in online there is only one order was passed for the substitution. That is in 835. IA number 835 in MAC appeal number 308. That is in item number 28. In that order, the order for the substitution was reflected in online. But in item number 27, there is an IA 846 for substitution of legal here of the respondent number 2. But in that IA, the order was not reflected. And 846. 846. And online there is a online in when we inquire about the online that in that the I was shown as not disposed, it is pending.
No, I 846 is for substitution.
Substitution in appeal number 337, that is in item number 27.
Whether in the item number 27, order of abatement etc. were also disposed of. The IAs were disposed of. No.
In online, it was not shown as disposed of. But as per instruction, it was disposed. And if lordship will see the appeal memo, then the registry is already modified the respondent number 2 and implemented. In both the appeal, lordship, in both the appeal, respondent legal error of respondent number 2 is substituted.
That and seem to record that concept that detail number and no order I said no order no I, but however the is there. No order is there. Order path. Okay, we allow because same
Same lordship.
But the equation orders are not there.
Lordship. The respondent.
One is both of no order is there.
Lordship.
Is there.
In both the cases, the respondent number 2 is the same. So legal here maybe the legal here is same in both.
In both the matters, legal are already
substituted in memo.
No order is there.
Okay.
And we should allow to issue note.
Oh. Highly obliged.
Yes, 29.
I'm seeking a small accommodation. The contracted council is frustration. I'm adjournment seeking it.
Which you are appearing for whom?
And for
respondent number?
respondent number 2, 3, and 5.
3 and 5. Artist. You're appearing on behalf of whom?
SP Chaudhary.
SP Chaudhary.
Yes,
You are MS?
B. Hazarika on behalf of R. Chaudhary.
What phone number?
2, 3, and 5.
Made by Mr. Hordica. Okay.
May I please your lordship? Lordship, my senior Mr. Eskemed is out of station. Kindly matter may be taken up on another day. On 22nd May, if possible.
It's in order column. You are appearing for whom?
Respondent number 1 to 6.
1 to 6.
1 to 6.
Who left? Yeah. Are there other respondents also?
No. Only
1 to 6.
One.
The appearance is completed. Right?
Yes.
Other respondent. Yeah, other respondent also.
Oh, airport authority is there. They are performer response.
Yes.
They are all performer.
Yes, sir. Lordship, I have one more prayer, Lordship. Two more RFS challenging the same judgment are pending. On the next date, all the matters may come.
Come first. It's still in order for. Start that part also hard. You are Mr.
And Buru appearing for S per
Hard.
It is your lordship. As per office note dated 25/8/23, service upon respondent number 2 is complete, and LCR is also received. The matter may be set for hearing.
I'm appearing for respondent 1, PK Patel.
Who is completed?
Who is complete? DS Degal.
Yes, Degal. That was a for office note 5/8. As well as 48.
So there's an IA 155 paying for injunction restraining the private respondent to change the nature and character of the plan.
That should be hard. Without hearing the other side, because anyway, comment and forget anyone. So here,
Let the private respondent appear then, because it won't be proper much.
Service was complete as per office note 25/8/23. So it was before August the service was complete.
no, but I have filed with the I filed. When you have filed the
I was filed along with the appeal memo.
I Otherwise, what had happened?
My lord can do one thing.
The petition is ready for hearing. In fact, we have received the LCR. It is already delayed. Though they have given the prayer for injunction, I think so. But the question is that it's already delayed because we have not raised the petition earlier. So it is already, it was most probably 1 year already that. The main case is ready for hearing. So let both the matter be heard together.
My lord, one more thing is the changing the nature is another thing. But for now, to stop further problem in the future, status quo may be maintained.
Here together.
So,
Will be heard along. Sharma, you are alone to the other side.
Lordship, in this matter, LCR is received
It has already received. You are for
from
which
respondent, sole respondent.
sole respondent. Then appears to support for the affected party. Your FPI also.
I'm appearing on behalf of K. Gogoi.
K. Gogoi. Appearing on LCA has already step 40 matter between for okay, it will be listed for
Always fine.
As per order date 3/5/24, we had filed an additional affidavit to bring on record certain documents which were annexed along with the plain. So the matter may be listed for admission because at the time of filing the first appeal, we did not annex the documents along with the plain. So we had short
So
time.
you have filed your additional affidavit.
Yes, sir.
Have you received the copy of the additional
I have not received it. I am appearing for respondent number 3.
for respondent number 3?
Respondent number 3. I have not received that particular document. So he will provide it, my lord.
Yes, come with the Amar Ahisen. We have received it's already been typed with the
I will serve
the copy. And the government side, you have also received the copy.
Yes.
No, a copy of the additional affidavit and other
yes,
documents.
we have received.
You have received.
But extra copies may be, sir.
To whom?
Because we have to send it to our office. The party, we have got one copy, but the copies will be required.
So you are for 3.
I am for the respondent number 3, GMT.
GMT. Take up. For 1 and for 1 and
As for respondent number.
That person to order it. 4 therefore back additional of that book asked to submit the copy of the additional to the respondent number 3. Next copy. One. That it may be listed for
admission.
It's that record.
May I please, Lordship, the connected IA has been filed seeking the interim maintenance amendment. The respondent had instituted divorce proceeding against the petitioner herein, and that was decreed against. And that permanent alimony of rupees 5 lakhs was awarded in favor of the appellant. But subsequent thereto, we filed the appeal, and in the IA, my lord, the impugn order has been stayed. And since then, my lord, we are yet to receive that monthly maintenance amount. IA 283823. So this present IA is only that seeking the monthly maintenance amount.
What about the permanent element?
5 lakhs was awarded. So prior to the judgment, my lord, I was receiving the monthly amount. But since the permanent alimony has been awarded, so since then they have stopped paying the monthly maintenance amount to us. And
So
since
now
the,
you have filed the appeal against the decree.
yes, ma'am. And that has been stayed in by in IA 2838 of 23, ma'am. Order dated 29/23. So since the impugn order has already been stayed, we are seeking the monthly maintenance from the date of judgment.
My lord, during the in the trial court, my lord, they filed one maintenance petition under section 125. My lord. That was awarded at rupees 3,000. My lord. That maintenance we are paying, my lord. And during this divorce petition, divorce suit, my lord, at the time this is filed with the husband, my lord. During the pendency of the divorce suit, the present appellant filed an petition under section 24. And lordship, well aware about that. For the Hindu Marriage Act, my lord, section 24 is pendency-like provision. It is the provision during the pendency of the suit. When the suit is disposed, my lord, and there is no specific order regarding the maintenance of in the suit, my lord, we are not liable to pay, my lord. That's why we issue payment, my lord, make payment. But in the maintenance case, there is another maintenance case, my lord, under section 125, my lord, that is awarded 3,000 rupees. That maintenance we are regularly paying, my lord. There is no
paying.
Yes, my lord, I am regularly paying, my lord.
So under what basis you are seeking for now?
Since the degree has been set on that basis, because the child is a girl child and minor, man. I am maintaining her only
that may be met without mentioning anything regarding the maintenance. Only the permanent alimony is mentioned, the 5 lakh rupees. That is also deposited. They did not receive because due to pendency of this appeal matter. And my lord, there is other provision also. If they think that we are not paying the maintenance due to change in circumstances, my lord, they may go to the maintenance court. That is the MR case number which was filed under section 125, my lord. They file an application under section 127, my lord. They will enhance the maintenance, my lord. This is not maintainable, my lord, at the present under Article 226. As there is alternative remedy, my lord.
As per from who filed the IA, that other IA 2838?
Present
You filed.
yes.
So you state.
Hello?
Execution of the award is stated by you only.
Yes, ma'am.
Yes. That
the final, because I am agreed by the both the degree and award as well as the amount.
Whatever, they have already deposited the money.
Yes,
From your prayer that has been stayed.
Yes.
Now you are seeking.
Even, my lord, what they are claiming, the 9,000 rupees, they are not entitled at present. As my lord, we are already paying a maintenance, my lord. If they think that that is not adequate, not enough, they may file a petition under section 127 CRPC for changing the circumstances. And my lord, if lordship come to section 24 of the Hindu Marriage Act, my lord, it is a specific provision, my lord. It is the pendency-like provision, my lord. Only
They already filed 2444.
The order, what they are claiming, this order is passed under section 124 of the Hindu Marriage.
No. They also preferred a petition for 24, section 24 Hindu Marriage Act.
Yes, ma'am. This is the order, my lord. The IA is what they are claiming. That is the order of the section 24, my lord.
24?
Yes, my lord. Lords may come to page 7, my lord, of IA. In the first line, my second line, my application under section 24. 24 is the specific provision only for during the pendency of the suit, my lord. When the suit is disposed, my lord, and there is no specific order regarding the maintenance, my lord, in the main suit, my lord, in the judgment, my lord, we are not liable to pay, my lord. Only there is the mention about the permanent alimony, which we were deposited, my lord.
pay for it. But with 24, you are allowed.
Yes, my lord, 9,000, my lord. Page number 7, my lord, the bottom paragraph. Last.
This is 24, it's 40.
My lord.
The pendency of that could already report
Yes.
or for you.
Only for the pendency.
But you have filed the appeal. The award was, the decree is stayed by you. Or
Yes. Even my lord, that degree also, nothing mentioned about the maintenance, my lord. Only permanent alimony, which we already do. And there is a maintenance case, my lord. If they think, I'm repeatedly saying that.
What is the maintenance case number?
MR case number 19 of 20.
Yes.
There you're still paying 3,000.
Yes, ma'am. Yeah, ma'am. I'm
Five. 3, 4. Wait. Oh. 3. What's it? Up. 3. Yep. 5. 5. 4. 7. 5. Planet ask or for payment of the 9,000 8,000 for the maintenance for the maintenance of the child and 15,000 for the per month. But then but by order 2009 that steady operation of judgment decree. Dated 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 20
Dated 16/8/23, my lord.
no, which one?
My lord, in the IA 2838.
The divorce petition, the award decree was
Award, yes, my lord, the judgment was 18/8/2023. Passed in title suit M 8 of 2020.
18.
16/8, my lord.
15. So last is M, second 0 is and after stick of it, order. It corresponded to 9,000 as per in person ordered it 9 12 21. Asked in which take this number 0 21. Incorrect. Yes, M 0 is record dependent with fact for it to respondent pay network per month to be applicable in person ordered 9 9 12 21 in past with number 0. Separate from the at time of passing of people and ceremony of permanent ceremony was to know 5 lakhs for a possible big amount, but that was not been drawn by the present applicant as order of the that put that by the present. Further is submitted that petition 24 of the Marriage Act to be owned to be dependency of the court as it is a provision by which the maintenance can be awarded due to the dependency toward health maintenance as well as maintenance as well as cost of profit can be awarded due to dependency. But here it already booked off with the award with the award and the pure divorce has been passed and the and permanent it was was what award was. However, there was no other order for any means must be made passed by done it because quite opposing people. However, subject the respondent is paid 60,000 per month as per order passed with MR with and the respondent has other fees for assessment of the state that allowed by finding appropriate activity under Section 1. But it is away by the benefit under Article not one. Connected a bit, order 16 but in ESM by finding I number I deposit for state I order digit when 0 more that not see that the respondent the affidavit of Mr. Parma. Is that subject counsel for if of that file of petitioner wanted for assessment of statement that of court of not after the two was award to the net not award per month towards maintenance spend. I find that present by the how it petitioner that happened by a good replicate for it not for one to answer.
Malad, in the connected appeal, Malad, the LCR has been received. So can it be taken up on 21st of May, Malad?
For what?
Hearing? Yes.
Native First would be possible. 28.
Malad, senior cousin Mr. Sahiwala won't be there, Malad, from 24th till last week. That's why.
Till last week of May.
Malad.
But he could not, it cannot be accommodated on 21st because lots of matters are already been.
Then, Malad, on 4th?
4th of June.
Much.
In this case, respondent number 1 has appeared. I have to take step upon respondent 2. So I am taking 3 days time for taking step by both way. Upon respondent number
She is for respondent number 1.
Yes.
Yeah, I'm here for respondent number 1.
1. For 2 you want to speak. I could not that. Take a
M. Malik.
M. Malik. Submitted. Next step. Takes the step that record.
It pleases a lot. Lord, these two applications have been filed for restoration and condonation of delay. Lord, the appeal was dismissed on 21st of March 2023. Thereafter, we had returned the file. Lord, notices may be issued. If the parties are going to engage us, we'll file as Wakalat.
But your name has been reflected.
My lord, my senior advocate, Mr. H.K. Dekka's name is reflected. It's okay. They're not going to pass it. That's all. They issue notice.
But there, I don't know. One is there, the restoration of RFS so and so, it was dismissed so.
Yes.
Again, in the matter of on date of, or those regulars were already implemented.
One is restoration, the first MC case number 86, and the other IA is for condonation of it. Delay in filing restoration application.
Your
My senior is S. Sahu.
S?
Sahu.
Sahu.
Your name.
My name is Suman S. I.
Your name could
Mine S. Sahi.
S. Tahin.
Shahi. SHAHI.
RMS 8. S. Sahi. And you are appearing for Mr. S. Sahu.
Yeah.
Appearing on behalf of Mr. S. Sahu for the applicant. Also for Mr.
A. Bhatt.
A. Bhatt appearing on behalf of Mr. Deveka. They were representing this one earlier, but after the dismissal of the when it was dismissed on
21st of March, 21/3/2023.
after disposal of RFA number 9 2015 on 21/3/2015. Right, and have taken stock that
Blood may not ask us to take instruction. Notices may be issued in these.
according to the response. Equity present I 5 under section 5 of the Act for contradiction of delay of 170 in framework restriction for excluding of RFA number 398 was for not on 21st of March applicant this record.
In this case also, I may be allowed to take step upon the respondent number 2, Lordship.
2 only. One is
One has appeared, Lordship.
one is hard to take that for the that service for and for and the respondent number 1 for or he cannot be requested based on LCR we have received the LCR. LCR for record 4. Okay.
Procedural, Lordship. This is a delay petition, Lordship. The delay was mainly because review petition was filed, but one defect my advocate clerk has done, Lordship. In the delay petition, I have annexed as per paragraph number 9 the order, Lordship, but that order was not annexed. I have a copy, the review order. The delay was mainly because of that review order, Lordship, but delay is substantial, 663 days.
This IA for 132 is for delay condition or this one is what?
Yes, 132 of 23 is for delay, condonation of delay, Lordship.
Then where you have to file the
Lordship, the page তুমি পাইছা নেকি নাই পোৱা নহয় this copy, Lordship, in fact we were supposed to annex it, we have mentioned it, but we have not annexed the copy of the order of the review petition. তুমি objection file কৰিবা নেকি
আমি বেলত কৰি টাইম ফাইলিং অবজেকশন
আগতেই কোৱা
এটা ঝামেলাটা আছে এইকাৰণে
মই দি দিম বাৰু তুমি জানাই কি কেতিয়াবা এপ্ৰিয়াৰ কৰিছা দেখোন কিয় ইমান দিন ফাইল কৰা নাই অবজেকশ্যন ফাইল কৰি কেছটো শেষ কৰি ল'ব লাগে
We are not file objection.
4 weeks লাগিব.
Okay, you will be allowed to file objection, but service is completed.
Yes, Lordship, service completed. Lordship will peruse office note dated 21/24.
Service complete.
Mr. Talukdar is appearing for respondent 1 to 5, I think.
1 to 4.
1 to 4. And
1 to 4. And 5 is
owner come driver, his AD
Service
card
is also-
arrived, flag A, Lordship.
So we have currency copy to him also. No?
I'll give Lordship. No problem.
Can be part of the
Let that be with the record. I'll give him. No problem.
also had September of the one year 4. It's not
21/24.
20 01 that the service is also completed on different file. In this context, Mr. Carter submitted he would practice against present it for prayer MS article also filed on the copy of order dated 13/1/39 2022 as it case number 2020 by Pepper Emit Nogam that will be part of the copy. It further that is the copy this recording. How many days you want?
4 weeks.
4 weeks.
We can say after vacation. We can say after vacation. We can start that. Highly obliged, Lord. It was.
Dear Lordship, my Lord, as per office note dated 8/12/2023, one is served, and notice on respondent number 2 and 3, neither AT card nor answer notice is received back, my Lord. I'll take fresh steps on respondent number 2 and 3.
2 and 3. 1 is served.
Sir, SK Chakravarti.
As per office note dated 8/12/2020, service is completed on number 1, but service is still available for respondent number 2. It is contact. It will be allowed. Should not expedite. Do not submit respondent number. It's better.
Yeah, please. Lordship, I press for adjournment, Lordship. As the senior counsel, Mr. Chinmay Chaudhary will conduct this case, Lordship. But his name is not shown in the cause list, Lordship.
So you are Mr. DK?
DK Sharma.
At the request made by the for the actor to the already submitted that Mr. who is counsel is conducting.
It's the Chinmay Chaudhary, senior counsel.
And accordingly, though his name is not reflected for it's accordingly absolute.
Lordship.
May I please, Your Lordship. As per office note dated 15/12/23, my Lord, respondent number 1 appeared, my Lord.
I am appearing, my Lord.
My Lord, so far respondent number 2 is concerned, my Lord, service is not complete, my Lord. I will take, my Lord, steps on respondent number 2.
It is the remark is that it is an insufficient address.
My Lord, I will take.
So try to collect if properties, if any.
Respondent number 2 is the husband of the appellant, man.
Oh.
That is. So by next
Why?
date, automatically it will be served.
Acha. Why she waited till next day?
That is why I was asking, my lord.
Hand-to-hand service you can give.
But my lord, that's then I will have to file an affidavit.
No, that's I'm joking. That can be delivered to.
Yes, my lord.
Only registered post lord.
Oh. Hard serve.
Hard serve.
Hard serve. Hard serve. You are Mr. H.
S. dot.
S. dot.
For respondent number 1.
Respondent number 1. As per office note dated 15/12/2000, it's not complete. Number 2. Direct request. List accordingly. You need 4 weeks or 2 weeks?
My lord, I need 4 weeks time to file objection.
Need application support. Also an application for it number 1 5.
Hello, my lord.
My lord, it's a matter of condolation of delay. Kindly issue notice to the other side. However, the other side has also filed a cross appeal. So their matter may be linked, tagged with ours. Their
Can you tell us the cross objection number?
RFA number is 3981.
RFA?
3981.
3981.
Oblique 23.
20. Just hard with notice. The one is part it is read by the council for the application. This along RFA number 91 is the present copy along RFA 981. Okay.
Wait, please, Lord. This is the continuation application. The service is complete, Lord.
APN 40.
Yes, Lord.
Yes.
So you are applying for?
Respondent number 1, opposite party, respondent number 1.
1. And you are for?
I'm for 2, 3, and 4.
We will file the affidavit in opposition, Your Lordship. When it's 2 weeks' time, as Learned Uncle's Council has gone to Bihar on the date of his uncle. So we need 2 weeks' time to file the affidavit of opposition.
And you are also going to file an affidavit? No. This I is for condolation?
Yes, Lord.
I'm appearing on behalf of other theory. Point on the 2, 3, and 4.
You are Mr. T. Devi.
Yes, sir.
You are applying for RS Devi.
Yes.
T. Devi appearing on you are Mr.
S.A. Bakhtiar. On behalf of NLM.
And Adam.
Respondent number 1.
Mr. Bakhtiar. For the appearance. 2 weeks will help you or 3 weeks?
After 28, it will be better.
After
20th May.
20.
Then after 2 weeks, or 3 weeks? After 10.
Some date may be fixed, otherwise it's very difficult to get the case listed again, Lordship. And there are cases, execution cases pending the court bill.
29.
Obliged.
Please, Your Lordship. Lordship, the matter pertains to continuation of delay of 246 days. Lordship, and the
You are for which respondent?
Respondent number 1.
1. Other respondent? What about the other respondent? Whether the service is also completed on respondent number 2 and 3?
yes, Lordship. It is completed, Lordship.
What? One Raktim Sutradhar had received. But who is Raktim Sutradhar? No, nothing. Raktim Sutradhar. You are Mr.
Yes, Saranya.
Part 8. Saranya?
Yes, sir.
R. Shah.
R. You want to file any topic?
Yes, Lordship.
How many days delay?
Lordship, the matter will be listed after 2 weeks.
How many days delay?
236.
236.
MS they may file report to another or by list according to
Lord, Lord, you may kindly give us a fixed date, Lord.
We have a date on 27/5. 27th of May.
Yes, Lord.
Okay.
Right.
Lordship, application for condonation, Lordship. Notice was clearly issued, Lordship.
Service is completed here.
Lordship, I am appearing for all the respondents.
All the
And we will file our objection.
What is the delay?
303 days.
You are Mr.
D. Dale, Lordship.
Hard Mr. D. Started appearing on behalf of applicant for hard MS.
D. Devi, Lordship.
B. Devi. Appearing on behalf of all the respondents. All the respondents have submitted that they did some more time by the accordingly 2 weeks or 3 weeks.
4 weeks.
Yes, according to and by this.
I the for the condonation petition. There is a delay of 50 days.
How many days delay?
50 days only.
50.
50. He was ill, Lordship. He was operated in Bhubaneswar Hospital, then Hyderabad. I have a stated medical documents also.
Yes,
I have
Mr. Bhattacharya, do you have any objection?
No.
He is saying that 50 days delay. delay is of 50 days. You are appearing for whom?
I am appearing for water resource department.
Water resource department.
We have filed our objection.
You have filed your objection already.
Yes.
My lord, a copy may be given to the us also because we have not been served a copy of the objection.
Right.
Lordship, I come to page 7, para 7, page 9,
No, we
Lordship.
hear the matter now. Are you ready to hear the matter for the hearing? Because we don't have time, in fact. That's why I'm not in a position to hear the matter. But the question is that we may give a project. So that
Yes, in the meantime, a copy may be served, so I can also come with that because.
Otherwise, as per his submission, only 50 days delay is there,
Yeah.
and most probably the medical ground.
But then he has filed the objection.
He has taken the mainly.
My lord can go through the objection and decide the case now. My lord.
What is the ground of your objection? Just I'm asking. I'm not going to pass the order.
I have written in paragraph number 5 that the grounds of preoccupied and he has stated that he was out of station and preoccupied with some urgent work. That ground we are denying, Lordship, and that medical ground we are denying. That's the point.
Medical ground is also. Okay, we'll list it. List it. 31st of May with 31st of May. We'll hear the matter. Otherwise, 50 days delay, it can be decided. 31st.
May I please, Lordship? Enhancement for appeal, Lordship. Condemnation of delay, Lordship, 222 days.
Enhancement for?
Appeal, Lordship.
What for enhancement?
Enhancement appeal, Lordship.
Achha, you have filed the appeal for enhancement.
Lordship.
But this is the delay condonation, I think.
Delay,
This
Lordship.
petition is for delay.
Lordship, 222 days.
So issue notice. This is first time you have come. This is first time. Issue notice. Registered. Let the issue notice first, then we hear.
It is an application for condonation of delay of 223 days.
How many days delay?
223.
223.
23.
So it is the first time we have
First time
so we
listed.
notice maybe hard listed. List according to 8 to 4 weeks, 7, 40 or 8 or 40. How many respondents are there?
3 respondents. Steps by both ways.
Registered date.
My lord, in respect of item number 55,
55?
55, it was mentioned at 2 p.m. I didn't know about the mention at 2 p.m. But Mr.
No.
R. Goswami told me in the first half that he has some difficulty in the second half. I consented. But it was directed to be listed after 2 weeks. My only prayer, a date may be fixed, man. I have filed one application for withdrawing of 50%. He has filed objection also. That may be heard. A date may be fixed, man. On 20th, can it be on?
Right. Take the 27 maybe a cover. 27 5.
Can it be on 20th, man?
It was that the fixed in fact. 20 is
Much obliged, man.
Lordship, item number 55. I am appearing for respondent number 4. Supplementary.
55 in the morning hour, Mr. Goswami took adjournment. Now he is